All right, WebEx is ready. Thank you so much.
Okay, good morning. Good morning, everyone. We are resuming our speech language pathology and audiology and hearing aid dispensers board business meeting at 9:01 on Friday, August 22nd, 2025. I'd like to start with calling off the roll. When you respond, please respond at your location with the name and the address, and notate if there are any other board members with you or any members of the public. I'll start with myself, Gilda Dominguez, board chair. I am at the Galeras Family Education Center at 427 West Carroll Avenue, room 2 in Glendora, California, 91741. And I have 2 other board members with me, and there are no members of the public present. Dr. Amy White.
Good morning. I am at the board office at 1601 Response Road, Suite 260, Sacramento 95815. I have 2 other members of the board here with me, as well as various board staff and no members of the public.
Thank you. Mr. Todd Borges.
Here, also at the Response Road address.
Thank you. Dr. Tamara Chambers.
Here, I'm also here at the Carroll Avenue location here in Glendora.
Thank you. And Mr. Francis David.
Here, also at the Glendora location.
Thank you. Dr. Charles Sanders.
Here at the Response Road location.
Thank you. Ms. Karen Chang.
Hi, I'm here at the law office of Scott Wormuth, 17700 Castleton Street, number 168, City of Industry, California 91748. And there is no members of the public with me.
Thank you. Ms. Burns, will you please announce who is present with you from the board office?
Absolutely. Myself, the executive officer for the board, and Michael Magat, our new assistant executive officer for the board, as well as Yuping Lin, our legal counsel.
All right, thank you. We will circle back to agenda item 2 for public comment for items not on the agenda as advised. I would like to ask the locations if there's anyone present that has recently shown up to provide public comment for items not on the agenda. Here at the Glendora location, we do not have any public members present. I'd like to check in with the Sacramento location.
At the Sacramento location, we have no members of the public.
Thank you.
Hi, at the City of Industry location, we have no members of the public.
All right, thank you. I'd like to ask the moderator to open public comment on WebEx at this time for public comment.
WebEx is open for public comment for items not on the agenda. If you'd like to make a comment, please raise a hand by tapping that hand button at the bottom of the screen. Dial-in users dial *3 to raise your hand. For our mobile device users, you may need to hit the ellipses button. That's the ... in order to find your hand. People will be given 3 minutes to speak, and I'll give you a 30-second warning before your time expires. We're going to take just a few more seconds to see if we have a request for public comment. Seeing no request for public comment, do you wish to continue with the agenda?
Yes, please. Thank you. We will now proceed and move on to agenda item 7, our executive officers report.
Good morning. This is your executive officer, Sharice Burns. And first up, I am very happy to announce that the assistant executive officer position was filled. We filled it on July 25th. It is filled by Michael Magat, who is in the room with us, and he was selected for the position and transferred here as of today. So this is his first day. Welcome. Thank you. He comes to us from the Board of Barbering and Cosmetology, where he has been a licensing manager for a unit of 13 staff. So we are very excited. We are fully staffed at the board office. Very excited about that. Can't be any more excited than I am at the moment. So wonderful update. No other positions are open that will be filled. And so we will continue to do training and get everybody acquainted after that. For outreach updates, on June 25th of 2025, I, along with other state licensing board representatives, many of them executive officers for their boards, attended a virtual ASHA town hall. So this was to discuss recent developments regarding the Centers for Medicare and Medicaid Services and their interpretation of licensure for speech-language pathologists, particularly its significant impact that it could have had on provisional licensees, like the board's RPE license, required professional experience license, and their ability to bill for CMS outpatient services. On July 11th of 2025, I attended the practice committee meeting of the California Board of Occupational Therapy. This was to engage in discussions related to the educational and training requirements for occupational therapists to obtain advanced practice approval to provide swallowing assessment, evaluation, or intervention. During this meeting, I was asked about our board's requirements for speech-language pathologists related to flexible fiber optic transnasal endoscopic procedures and about modified barium swallow. Both of those meetings were positive and informative. I will continue to be monitoring advancements at the Occupational Therapy Board, especially in relation to swallowing assessment, evaluation, and intervention. For the budget, yay, happy things to report. The board continued to actively reduce current year expenditures and closely monitor spending. This was done to ensure adequate funding to continue upholding consumer protection through enforcement actions, as well as fund the board operations while achieving savings mandated by the governor. Included in the board meeting materials is the 2024-2025 budget report, fiscal month 12, FM12 is what fiscal month. And that reflects the operating expenditures through the end of the fiscal year. And due to our restraint and settlement of one of the board's disciplinary cases prior to hearing, the board has a very healthy reversion of $113,229 for last year, which is a common surplus around 3%. Very happy, 3.259. It's great. Also included in materials is the fund condition, and that was prepared as of August 12th. It's a snapshot in time. Again, our fund condition is like our savings account. It's what our appropriation and our budget is taken from every year. And that is healthy and continues to grow. You'll notice that it's going up from 6 months in reserve up to 10 months in reserve 3 years out. So that is a very healthy fund. We are very happy to be at that point.
Sharice,
Yeah.
not to interrupt. I think at the last board meeting, we were talking about, because of enforcement actions, there was kind of like a different pot of money maybe to request coverage because the enforcement actions were costing so much extra. Did we end up not having to go that route because of this? And
we did have to ask for that extra money.
Okay.
It is not a different pot. It's still our fund.
Okay.
So we are completely self-funded. Anything we do comes out of our fund, which I call the savings account.
Uh-huh.
But we have a special authority via statute to say, hey, I'm over in AG spending, Office of Attorney General, or I'm over in Office of Administrative Hearing spending. We've requested that for AG spending, not for OAH. And thankfully, with the one settlement, we were nicely underneath it. So instead of having a 0 point something reversion, we ended up with the 3.
Cool.
We also, didn't buy extra supplies. We are running out of paper soon. So we're about to order supplies so that we can carry on. But we stopped everything, including a couple laptop replacements, one of which already died. Thankfully, we had one left for that person, but now we need to start replacing. There's also some IT needs with the new Windows 11 that'll be coming. So thankfully, this fiscal year should look better.
Thank you.
Under the regulations report, these are pending rulemaking files, so they're in the official rulemaking process. The rest of the regulations report, Maria will cover in agenda item 19, I believe. So these are just the 2 that are in the official rulemaking file. Both have proceeded to the Office of Administrative Law. We should have decisions for both of them by late September on the 23rd. So those were 2 of our smaller packages that were easy enough to get through the process while we're also working on our disciplinary guidelines, which are a behemoth. So that was thankfully something we could put through the process. When it comes to licensing, I continue to be very pleased to report that we have continued to keep processing times low, between 1 and 2 weeks. This has been a Herculean effort. We know the timeframes, if you look up at 23, were difficult while we were building the airplane, while we were flying it. But now that the online licensing for initial application has been thoroughly put through, and we're now just in the maintenance phase, we continue to keep 1 and 2 weeks. That means it's an overall reduction compared to 2020, 2021, and 2022 of 71%. I don't compare it to 23 because that was an aberration year, and that would just kind of tilt my statistics in my own favor, but I don't do that. But as you can see, monthly, on those months where it was higher demand, usually around graduation time, those are the months with the significant impact. And so that continues to be great. Again, for complete applications, you're looking at 1 to 2 weeks. It's been pretty steady throughout the year. Occasionally it goes up. People get to go on vacation. It's just part of life. The other part being is that I know we don't talk about it a lot, but incomplete applications are also still holding steady between 2 and 3 weeks throughout the year. So even those that make mistakes on their application are still licensed within 30 days. So oftentimes we get the complaint that it's just about complete applications, but even incomplete applications. People are getting those notices from the system. They can respond. The board can continue processing their application. For practical examinations, the memo has the June 13th and 14th, 2025 exam results. Those are provided for your information. 68% of those applicants passed and 32% failed. The next practical examination is in September 26th and 27th. The filing period ends on August 21st. And for the enforcement report, this is actually a pretty big change. So the board has received 269 complaints and subsequent arrest notifications through the end of last fiscal year. So during the same period, the board had 36 citation and fines, including continuing education citations and fines. We have 5 formal disciplinary cases that are still pending at the Office of Attorney General. We had stopped and paused sending more cases to the Attorney General unless they were urgent until the new fiscal year, so that we were conserving money for our most important cases. We have now started sending those cases over again. The board is currently monitoring 14 probationers, 5 of which require drug and alcohol testing, and 3 that are in hold status, so they're not practicing or out of state. The following are the Attorney General outcomes. They were adopted by the board. 1 is a petition to terminate probation due to the petitioner's good job at completing his probation. And the rest are either initial discipline or subsequent discipline against a probationer that has failed to complete or failed to follow their probationary terms and conditions. And then lastly, the CE and CPD audit. So we started out doing the December 2024. We started doing CE audits, 5%, a random sample of speech language pathologists, speech language pathology assistants, audiologists, and hearing aid dispensers. That was started for the January 2024 month. We have since gone all the way through June of 2024. We still have some people that are outstanding. It excludes a small number who have been having approved extensions. They may or may not be outside of the country, and then when they come back, they have to provide it within a certain number of days. We have a few instances where we also have health issues. So we are following up on all of those. But in general, unfortunately, the passage rate is somewhat low. The best is 61% and the worst being 49%. There are many that have failed, and then we have more and more that we make sure that an exemption, if it qualified, was granted. So again, if there is a personal disability or health-related issue during the renewal period, or you were caring for a spouse or relative, parent, so on, that was disabled during that time period, you provide us the documentation, we provide the exemption approval. Many licensees do not know about this, so I'm just saying it to hit it home. If something occurs during your renewal period, you should reach out to the board, let us know, provide the documentation so that the exemption's on file. Even if you do end up being able to make up all those CEs, just in case you don't. So better to have the exemption than to not and then get audited and then fail.
Can I ask, the predominant reason for the failures? Was it the exemption issue, or was it just not doing the CEs properly?
Not doing the CEs properly. Wrong renewal cycle, not approved providers, but the most common, it's all self-studying, and they were not getting live.
Right. I was just going to ask. Let me guess. It's live, right? Okay.
We've explained it many times. I think they
Right.
get it now. There's been a lot of confusion. There was also a lot of laissez-faire attitude about what the national associations require versus the state board. And we remind them, this is your license to practice here in the state, and you need to take it seriously. We have different requirements, you need to keep them in mind. They also are different year requirements, and some people have stumbled onto that, where they were on the national time clock of 3 years rather than the 2-year license that they hold here. So, but just to
or
make sure,
1 year license for it.
yes, for dispensers.
Right.
In the dispensing side, there is sometimes a little bit of confusion about, again, 50-50, right? So if you're a dispensing audiologist, 50% hearing aid, 50% audiology. Some people took all of one, all of the other. We didn't run into many with the indirect care problem, so that was comforting. So most people are taking direct care and related to the profession courses, so that's comforting. That's a very good mix of the types of classes they're taking. There has just been a laissez-faire attitude about dates, whether or not the provider or the course is approved or not. And so some of them we will be following up with, since they are California licensees providing the training, but they have not gone to get approved. Not that that's illegal, but you should probably provide the disclaimer that this doesn't count in the state you're actually providing it in. So unfortunately, we have quite a few of those. So I think now that we've seen a handful of this, we should at least reach out and say, hey,
Gotcha.
you should probably put a disclaimer on here, because it doesn't count here, and you're right here in California,
Right.
and you're all over. So.
Thank you.
But overall, fiscally healthy, enforcement is up, licenses issued is holding steady. It's a few less than in 23-24, so we had 5,181 licenses issued last year, which again, we used to only process up to about 4,200, and we now get up to 5,300 if there's that many applications. But remember, in that year, we were attacking the backlog that was created while we were creating a system. So we're very pleased that the online system increased capacity as well as speed when we're processing applications. The one thing I would point out, and of course, it could always have an impact on the cases the board is seeing, complaints have this year finally rebounded to pre-pandemic levels. So pre-pandemic, we more often saw 250 to 300 complaints per year, and that was more of the average. During the pandemic and the following years after, it got pretty low. It has gone back up. Unfortunately, so has the convictions that we're receiving. So people are not making good decisions in relation to the law. But that does get us back up to our more normal levels. So there was a question at the board for some time. If we don't see a rebound in the number of complaints, should we be looking at how we're organized and redistribute staff? Now may not be the time. So we'll have to see how next year goes, but we may have to put more back into enforcement. So those are the outcomes. In general, we had a good case closure rate. Again, complaint numbers have gone up, so average days to complete has gone up a little bit. We're not using DFI as much, but we've had more complaints this year that we were sending to the Division of Investigation. They have changed their priority categories on what they will investigate versus what they send back to the board to investigate. And that has changed significantly for our board. It's something we have not done before. So we are looking at additional training and assistance for our special investigator to do more of the work that Division of Investigation was doing, to go to locations or do interviews and things like that. So there is some inner workings that we're having to iron out. Citations are up. It might look kind of awkward because we went from 467 to 36. I would point out that a large majority of those citation and fines are related to failing the CE audit. So now that we are auditing on an ongoing basis, you will probably see more citations and fines. due to not passing their CE audit. And then, of course, when it comes to Attorney General cases, our outcomes are on the last page. We put 3 people on probation. We got 2 license surrendered, and we had 3 revocations with no stay order. So that means we took their license. They don't get it back unless they petition for reinstatement. And that's a total of 8 disciplinary actions last year. We have 2 large cases that the board was accruing many expenditures for, one of which we have a license surrender after the new fiscal year. So that is in July. The other one is still in the works with the Office of Administrative Hearings, and we won't have that for a few months. And that is my report. Do we have any other questions from the board?
Thank you, Ms. Burns. I know there were questions that were being asked during your presentation. I'd like to open it up for additional board discussion at this time. I'd like to welcome Mr. Michael Magat.
All my
looking forward-
fellow folks can get to meet him in person at our next board meeting.
Yes, looking forward to that. So again, welcome and looking forward to working with you at our capacity. And glad to hear about the budget. So thank you for that, Sharice, Ms. Burns sharing that. And then processing times, very impressive. Again, the hard work that you and your team are doing to make sure that these are timely for those who are eager to get started in their professional career. Well, thank you.
You're welcome.
I had a question about the average days to discipline. It seems like the cases went down for 2024, 25, but yet the average days to discipline went way up. Was that just an aberration, or there were just some outstanding complex cases?
There were a couple complex cases that had to stay open until the conviction resolved. So the criminal conviction is what that was waiting on. So it's an extraordinary number. When we close a complaint and refer it for discipline, sometimes we have to wait for all of that to resolve before we take action. A lot of that is in there. There are a couple as well that they took a long time to investigate. When the board's investigators got in there, there was a lot more violations that they found once they started digging. So a couple of those cases kind of upped our numbers pretty high.
Okay, hearing no further board discussion, I'd like to open for public comment. At our location in Glendora, there are no members of the public present. I'd like to check the other locations.
In the Sacramento location, there are no members of the public.
At the City of Industry location, there are no members of the public.
Thank you. I'd like to ask the moderator to open public comment on WebEx at this time.
We are open for public comment on the Executive Officer's report. If you'd like to make a comment, please raise a hand by tapping that hand button at the bottom of your screen. Dial-in users, dial *3 to raise your hand, and we will call on people in the order we have requests. We're going to take just a few seconds to see if we have a request for public comment. Seeing no request for public comment, do you wish to continue with the agenda?
Yes, please. Thank you. I'd like to move on to agenda item 8, the legislative report, update, review, and possible action on proposed legislation. I'd like to ask Ms. Lorenzo to provide the legislative report at this time.
Thank you, Ms. Dominguez. As you can see, we are far along in the legislative calendar. The legislature reconvened from summer recess on Monday and is on its way to end the first year of the 2-year legislative session. Most bills have reached the other house and is either in the fiscal committee or on the floor. Most of our bills are on watch list, so I'm just going to highlight some of the changes to some of them. So there are 5 bills that are considered 2-year bills, which mean that they'll be taken up next year when the legislature returns to the second year of the 2-year legislative session. And that's AB AB 364 regarding maintenance of personal information, AB 970 regarding child abuse and neglect reporting, AB 1015 regarding discrimination and harassment prevention training, AB 1110 regarding notice of safety rules and regulations, and AB 1192 regarding reporting of child abuse or neglect. We do have one bill on the watch status that was chapter, and that's AB 784 regarding special education and specialized deaf and hard of hearing services. At the last meeting, board members did ask what this bill specifically does. And so what it does is that it responds to confusion among local educational agencies regarding specialized deaf and hard of hearing services um, that may be included on an IEP as a standalone support. What has been happening is that some schools, districts have been providing accommodations through a Section 504 plan, which offers fewer procedural protections and does not include specialized instruction. So this bill would allow services for deaf and hard of hearing um, to be provided as a standalone service on an IEP. We do have a couple item bills that we have added to the watch status. AB 322 regarding precise geolocation information. What this bill does is that it will require a business that collects precise geolocation information to prominently display a notice to the consumer whose information is being collected that states certain information related to the collection of information and its use by the business when information is being collected. This bill would prohibit a business that collects precise geolocation information from retaining the information no longer necessary to provide the goods or services requested by the consumer, or no longer than 1 year after the consumer's last intentional interaction with the business, whichever is earlier. We also have SB 82, which would limit the dispute resolution term and conditions to the use, payment, or provision of the good, service, money, or credit provided by the consumer use agreement. This bill would make a waiver of these provisions void and unenforceable, and would require that the provisions be liberally construed for the purpose of protecting consumers. The bill would provide the duties and obligations it imposes are cumulative with and do not limit or expand duties and obligations imposed under any other law and do not limit any rights or remedies under any other law. The bill would define terms for the purposes of this provision. And then the last new item we had was SB 294 regarding the Workplace Know Your Right Acts. This bill would establish the Workplace Know Your Right Acts, which would require an employer to provide a standalone written notice to each current employee of specified worker rights. This bill would require that the said notice be provided within 30 days after the Labor Commissioner has posted the template notice on its website and every year thereafter upon hire of each new employee and to an employee's authorized representative. This bill will also require that the employer notify the designated emergency contact if the employee is arrested or detained on their work site. If one has been if a contact has been designated. And this bill would prohibit an employee from discharging, threatening, or to discharge, demoting, suspending, or in any manner discriminating or retaliating against an employee for exercising or attempting to exercise their rights under this act. So that's pretty much, oh, and then lastly, there were a couple bills that were amended since the board last met. AB 346 regarding in-home support services and licensed healthcare professional certification. Amendments include changes on how licensed healthcare professionals is defined. Also amended was AB 485 regarding unsatisfied judgments for non-payment of wages. Amendments include repealing requirements for employers in long-term care industry and allow state public health officers to exempt a hospital employer from requirements. We also have AB 724 regarding licensing applicants who are descendants of slave. Amendments include changes to expedite applications. SB 81 regarding health care facilities and information sharing. Amendments include changes to prohibit unauthorized disclosure of medical information to immigration enforcement and specify that a court order is issued by the state court. And SB 446 regarding data breaches and consumer notification. Amendment includes changes to require the AG to be notified of security breach within the specified days of when the consumers were notified. And so that's pretty much all the changes since to the boards to the bills that we are tracking since the board last met. Are there any questions?
Thank you, Ms. Lorenzo. I'd like to open it up for board discussion at this time.
I have a question about SB 470, the Bagley-Keene Open Meeting Act.
Yes.
So basically what this is extending the teleconferencing ability of the board through 2030, correct?
Yes.
The newer provisions,
Right.
Yeah.
There are some different provisions.
not the
there.
ones we're using right now.
Correct. Okay. That's what I was getting.
We're
from that.
technically a traditional teleconference, just using via WebEx, and
Right.
so we're on the pre-pandemic rules.
So I guess the only question I have is if this doesn't pass, then everything reverts because come January 2026, which is 4 months from now.
That's why I've kept you on the same old rules we've always known.
Okay.
Yeah,
So does this mean we would have to go to all in person then after 2020? Or we
because
just,
regular teleconference via phone or WebEx is offering us the phone essentially.
right.
That's all we're using. So you can use regular teleconference where every location has to be publicly noticed.
Mm-hmm.
The other provisions were about not having to publicly notice locations, especially if somebody was ill, right? You could take the meeting from your home and you didn't have to put it on the agenda, but everybody had to have their video on. That's all those new rules. We haven't had to use any of that.
Okay.
So our normal in-person and strictly teleconference using WebEx is what we've stuck with. So no matter what this bill does, we're not really affected.
Okay. Well, it does say something about being all cameras on during the operation.
That's if you use those rules.
Right.
So,
Assuming this passes, then we'd have to convert to those rules.
you don't have to convert to them unless you want to use those provisions.
Oh, I see.
So
Okay.
where somebody's
You're
not
basically
publicly
being an
noticed.
Oh, gotcha.
Yeah.
Okay.
I'm
Thank you.
essentially using WebEx as a telephone.
Okay.
So
Thank
you just get a visual.
Gotcha. That's all. Thank you.
All right, thank you. Hearing no other board discussion, I'd like to.
Sorry.
Sorry.
So I just wanted to. I know the board has a lot of questions on some of the artificial intelligence, the bills related to artificial intelligence and data and geofencing. So we were able to look. I did have our legal counsel look at some of those. Most of them are going to be consumers having to go seek, if they have complaints or issues with their location data and things like that. A lot of them would have to be are enforced by other entities such as the AG or the California Privacy Protection Agency. The only bill that the board has enforcement authority is AB 489. Related to artificial intelligence using terms and letters of healthcare professions, such as like doctor or DO or an MD. And then let's see, and I think that's pretty much it. That I think also in regards of does it apply to like who is the person in question? For most of the bills, a lot of them may include licensees, whether they're as licensees as a person or licensees um, as a business owner. But for the board purpose, we would really focus on AB 489 when it comes to enforcement.
All right, thank you for clarifying that. Are there any other comments or board discussion? Before I move on, I just wanted to make sure, Ms. Lorenzo, that you were done with your presentation.
I am, thank you.
Okay, thank you. Is there any
So,
other?
yeah, sorry, just a quick, so when we get through the season and all the bills have been either passed or not, we'll get a good summary of that. I assume we always do. And at that time, if any of these geofencing, AI, et cetera, then the board would be able to discuss at that time, like how we are going to interpret it and look at enforcing it, or at minimum, at least educating our licensees about it, because I think there's like 4 or 5 of them in here. There's a lot. And they're very nebulous in a lot of ways. And so I think, it can be interpreted that many of these are going to, could have a significant impact on the way a lot of our licensees do business. So I just want to make sure that we.
Yeah, so generally, oh, sorry, I was going to say generally when it comes to like specifics of how to operate and run a business, we always advise licensees to seek legal advice because it's outside of the jurisdiction of the board in some of these cases. So that will definitely be one thing.
So is it not then, okay, so then it's not really the board's responsibility in terms of enforcing any of these. It would be outside of the board's jurisdiction. They would, the license would be hit.
So I'm going to clarify this. So
Okay.
I'm going to pause you both.
Okay.
So first, every year we do a legislative advisory where we talk about what was chaptered and what does it mean for our licensees. So that will, of course, be done and come out usually at the end of the year or beginning of January. That will explain how does it impact licensees and or the board. For items that are outside of our jurisdiction, enforcement may get the complaint still and then have to say, this is outside of our jurisdiction, and we refer you to Office of Attorney General's. This is outside of our jurisdiction, you need to file a civil suit because this is civilly enforced. That's where we help consumers with where do they need to go next. And then those that we can enforce, of course, we would open the complaint and work with the licensee. So that's usually how this will go. Maria's point, the board is not everybody's attorney, so we do not provide legal advice on how to organize your business, the nitty-gritty of day-to-day operations. We will tell you the laws and what is restricted, and then you need to go forth and ask your own attorney about how to do that. I think sometimes people, again, think we're the association. You do have professional associations that the lawyers of which can help you define those things. That's not us, but to the extent that we can give a summary of the legislation, how it impacts licensees, we do that every year, and that will be done as well.
Okay, awesome. Thank you.
Any other comments, questions, board discussion? All right, hearing none. I'd like to check in with the on-site locations for public comment. We do not have any members of the public here at the Glendora location.
The Sacramento location does not have any members of the public either.
The City of Industry location has no members of the public.
Thank you. I'd like to ask the moderator to open public comment on WebEx at this time.
WebEx is open for public comment on the legislative update. If you'd like to make a comment, please raise your hand by tapping that hand button at the bottom of the screen. Dial-in users dial *3 to raise your hand, and we will call on people in the order we have requests. We're going to take a few seconds to see if we have a request for public comment. Seeing no request for public comment, do you wish to continue with the agenda?
Yes, please. Thank you. I'd like to move on to agenda item 9, legislative items for future meeting. I'd like to ask if there are any legislative items that the board may want to discuss for future meetings.
Hi, Maria Liranzo. We do have one that we will be adding to the watch list, which is SB 744 regarding accrediting agencies. This bill would state that for the purpose of California law, a national or regional accrediting agency recognized by the United States Department of Education as of January 1st, 2025, who and loses the recognition will retain that recognition until January 2029, provided that the accrediting agency continues to operate substantially the same manner as it did on January 1, 2025.
Thank you. I'd like to open it up for board discussion at this time. Okay, hearing none, I'd like to check with the on-site locations for public comment. We do not have any members of the public present at the Glendora location.
There are no members of the public in the City of Industry location.
The Sacramento location has no members of the public.
All right, thank you. I'd like to ask the moderator to open public comment on WebEx at this time.
We are open for public comment on agenda item 9. If you'd like to make a comment, please raise a hand by tapping that hand button at the bottom of the screen. Dial-in users dial *3 to raise your hand, and we will call on people in the order we have requests. We're going to take just a moment now to see if we have a request for public comment. Seeing no request for public comment, do you wish to continue with the agenda?
Yes, please, thank you. I'd like to move on to agenda item 10, discussion and possible action to propose amendments to statutorily approved continuing professional development providers as stated in BPC section 2532.6. I'd like to ask Ms. Burns to present information on this agenda item at this time.
Thank you, Board Chair. So during the course of the continuing education audits, we continue to find issues that may arise that the board might want to consider. In particular, we've had to educate many current licensees regarding acceptable types of CPD and approved CPD providers. During this process, board staff has raised some questions as to whether some of these issues might merit being included in our sunset report. Of course, that's our every 4 years we go before the legislature to be continued as a board. So currently, under Business and Professions Code 2532.6, the required CPD has to come from an accredited institution of higher learning, organizations approved as continuing education providers by the American Speech Language Hearing Association, American Academy of Audiology, or the California Medical Association Institute for Medical Quality, and then entities approved as continuing professional development providers, or PDPs, by the board. This is on the speech and audiology side, I would clarify. It also exempts the following entities from any application or registration fees. So the universities, accredited institutions of higher education, do not have to be approved. And those ASHA, AAA, and CMA do not need to be approved by the board either. So as we prepare for our sunset review, it only seems logical to the board staff that we should also clarify that the subsidiaries of those national organizations or the national organization for the California organization should all be named. So it names the American Academy of Audiology. It should probably name the California Academy of Audiology. It names the American Speech Language Hearing Association. We should probably name California Speech Language Hearing Association. Same thing with California Medical Association, naming the American Medical Association. They all have the same standards. It's all very equivalent. The one that I do believe, after reviewing quite a few CE audits and fails, is also the question of whether we want to allow federal, state, or local government entities So currently, many speech language pathologists and some audiologists are taking mandatory courses for their jobs that were required by the California Department of Social Services, California Department of Education. There's a couple other, and they are related to the provision of service. So they're not just the you have to do sexual harassment training every year, those kind of things. They are related to the services they provide for either regional centers or whatever the facilities they're working at. Currently, none of those are approved because, of course, the state agency is just contracting with somebody to provide the training. They're not concerned that, hey, you speech language pathologists can't use this towards your continuing education. Often these are live in person or live webinars, so they're also an opportunity to get your live requirements through something that actually is helping you in your provision of service. So it seems to me, at least, that this is an opportunity that we could add one federal, state, and local government outside of the, let's clarify, the national and state organizations. Yes, please. But to add federal, state, or local government entities. So if you're required to do it by the California Department of Social Services in order to provide regional center services, and it's about the provision of your speech services, shouldn't we be allowed to count it? That's kind of the question we're asking here. We've put that language into the mock-up because anything, of course, we take to sunset as a new issue. We have to have the board review and approve it. So it is here for your perusing. So we recommend that you go ahead and review the legislative proposal and then see if you'd like to have parity national to state organizations, as well as the local, state, and federal government entities.
Yeah, I'm happy to see this. I think that, working at the VA, we have a similar situation with a lot of, coursework that our speech language pathologists and our audiologists, are required to attend, and it is in person or it is live. And we, it is, all of the units are usually coming from the American Medical Association, but that's not named yet. And then, so we run into that same thing working at the federal level and the hospitals of not being able to count a lot of the things that are relevant, that do matter, but we're just not able to count it yet.
So you're wanting to basically dovetail this in, so they're having to do things twice.
Exactly.
Right, which makes perfect sense. The assumption being that whatever government entity this is still ahead of time presenting you with the course so that you know that it's an actual applicable course and you approve it, or are you saying they're exempt from?
They don't. We don't have to approve it. The only provision outside of that is our general CPD rules do require that it be related to your practice. So it can't just be any old course you want to take on the audiology and speech side. And so then the CE auditor can say, hey, I see you took this course, but I don't understand how that relates to your practice as an audiologist or a speech language pathologist. And then you need to clarify it to us. And then if it passes muster, we'll go ahead and count it. If again, we see it's sexual harassment training every year, that's not going to fly. If it's something like that, or I will give you a good example, prior board, right? There was a person that worked in hospitals, but the course I saw was about ankle fractures and pain management. And I said, I'm really sorry, but you're going to have to explain to me how this ankle fracture and pain management course impacts your practice as a psychologist. Well, that psychologist works with them on pain management issues, and this was related to what he does with those patients. So, okay, I get it. So it's not an automatic pass, but we do need to see it and see what it's about, and then you explain it.
Which is how it already is for audiology and speech pathology.
Generally,
if you're getting from any,
they get these
So
providers.
you're basically allowing them to kind of backfill into you the reason why they're asking.
Yes.
Assuming you see it and you question it.
Yeah. You would in audit.
Right.
So those that get audited, our auditor looks at every single class.
So unlike a typical CE class for dispensing where it has to be approved ahead of time, but it's covering the topics, they're basically just in essence getting a pass and having to justify it up front with the understanding that they have to be able to justify it
on the
back end if you question it.
Because they do on the audiology and speech side, they approve the providers. And then we have the ability to audit courses after that. So it's more of a front load instead of a back load. For hearing aid dispensing, it's something to look at in the next couple of years. Is the course by course approval method what's necessary, or is there room for hearing aid dispensing to move to a provider model where the provider is approved and then they provide multiple courses? We occasionally check in on those courses to make sure they're appropriate, but we no longer need to go course by course. So I know these are outgrowths of the former system where the hearing aid dispensing was the bureau and it's separate and it was course by course, and then the speech and audiology have always had providers. So it's something whether to look at, we need to look at the parity. Currently, we don't have a lot of capacity to audit all the providers very frequently, but I'm hoping to work that into the continuous auditing process. So, and if we had that and it was robust, it might be worth looking at, why don't we have one system across the board for approving providers?
Right. Well, now that we've expanded what courses are allowed for dispensers, I can see that as being more of a possibility than what it was, what it was prior.
Yeah.
So yeah, we definitely want to bookmark that.
Yeah. I had a feeling.
Yeah.
There's also a certain amount of, it's helpful for the board staff, and for licensees to have a consistent understanding instead of, here's one way you can do this for this, here's one way you have to do it for the other side. And hey, dispensing audiologist, make sure you hit both sides, because your audiology courses are approved one way and your dispensing courses are approved a different way.
Right.
So that can also get complicated as well. But hopefully this adds a couple more avenues, a little more clarity, and again, courses that are already impacting these professionals in their license capacity, one more avenue for them to be taking courses that really apply to what they're doing, rather than having just to hunt for anything that's live and online.
Thank you.
Yeah. Okay.
I do think that this is really good. Having recently done the opioid training course that I probably otherwise would not have done as part of my licensing, I think that it does make for more well-rounded providers overall to look at some of these, kind of other things that are adjacent to our practices, but still really important in terms of caring for the whole patient.
Absolutely.
Okay. That's all we have here. I agree as well.
Karen, do you have any concerns or questions?
No concerns or questions.
Then if the board is in agreement, we have language. You can just approve what's noticed, or if you have amendments to the language, we can also talk about amendments. Hopefully we've captured things in a well enough manner that we can approve as noticed. But
Are there any amendments that are being requested by the board? Okay, hearing none, I'd like to ask for a motion regarding adopting the legislative proposals be included as part of the board's sunset review as noticed. May I have someone for a motion and a second?
This is Todd. I move to adopt the legislative proposal to be included as part of the board sunset review as noticed / amended.
It's Dr. White, I'll second.
Okay, thank you. It'll be as noticed, correct?
Yeah.
yes.
Okay, thank you. I'd like to ask for public comment at the on-site locations. Here at Glendora, we do not have any members of the public present.
Here in City of Industry, we do not have any members of the public present.
In Sacramento, we do not have any members of the public present.
Thank you. I'd like to ask the moderator to open public comment on WebEx at this time.
WebEx is now open for public comment on agenda item 10. If you'd like to make a comment, please raise a hand by tapping that hand button at the bottom of the screen. Dial-in users dial *3 to raise your hand. And as a reminder to our mobile device users, you may need to hit the ellipses button. That's the ... in order to find your hand. We're going to take just a few seconds to see if we have a request for public comment. Seeing no request for public comment, do you wish to continue with the motion?
Yes, please. Thank you. I'd like to ask Ms. Burns to conduct the roll call vote.
Absolutely. Ms. Dominguez,
Aye.
Dr. White. Aye. Mr. Borges,
Aye.
Dr. Chambers. Aye. Mr. David,
Aye.
Dr. Sanders,
Aye.
Ms. Chang.
Aye.
Motion passes.
All right, thank you. We'll move on to agenda item 11, discussion of possible action to propose amendments to statutory requirements for continuing professional development for speech language pathology assistants as stated in BPC section 2538.1B6. I'd like to ask Ms. Burns to present this information on this agenda item at this time.
Absolutely. Thank you, Board Chair. So this is another one related to outgrowths from our continuing education, continuing professional development audits. Currently, this is about the speech language pathology assistants because they are in a different statutory section. They have their own section. So originally, the legislation in 2538.1 B6, it was very specific. It says only the completion of state or regional conferences, workshops, formal in-service presentations, independent study programs, or any combination of these concerning communication and related disorders. The board had never actually defined independent study programs, and the regulation currently just mirrors the statute, which long time ago would not get rejected. It would now get rejected if it's just a repeat. So applying these, we had the question of, and the Speech Language Pathology Committee discussed it yesterday, should the speech language pathology assistants, or SLPAs, essentially be allowed to take coursework from those that are the state or that their supervisors can take it through, which is accredited institutions of higher learning, coursework through the national and state organizations, and then coursework through other continuing professional development providers with the board's approval. And then whether or not we can just go ahead and extend these to the speech language pathology assistants, of course, with the caveat that they are related to their practice as a speech language pathology assistant and are not related to the accrual of a master's degree for the purposes of licensure as a speech language pathologist. I would say that yesterday during the committee meeting, they struck the independent study program shall have the same meaning as self-study as defined by the board and regulation, instead preferring to define independent study program via the regulations. So if the board would like to approve the changes that the Speech Language Pathology Practice Committee is approving, it would be as amended. And the language is provided in your attachment.
Maybe Ms. Dominguez, can you just give us a quick, what the thought was behind getting rid of the provision for independent study? I mean, was it just that there was no actual definition of what that meant? And is that going to have any impact on your SLPAs now and how they get their education?
Yes, we here, as members of the committee, we're requesting an operational definition of the independent study. And with conversation from Ms. Burns, it fell in line with just
self-study.
adding, yes, right. So adding it to the current format that they have in place right now.
All right, so it's not assumed then that there are a number of SLPAs that are receiving their units by some other self-study program that's been created. I don't know, like anything other than.
We currently aren't seeing it during the auditing process. It's just they're literally going out and taking self-study because their supervisors didn't give them guidance. So they just went ahead and took whatever ASHA was offering.
Got it. Okay.
Yeah. Does that add clarity?
5% for auditing, but that's what we're seeing.
So Dr. White, did that answer your question on our end from the committee?
Yes, ma'am. I just wanted to make sure we weren't taking away something that was being utilized in some way that I wasn't aware of. That's all.
We just wanted to make sure there was clarity. Yes.
Yep.
It would still exist in the statute, and then we would just, at this point, since we're not defining it in statute, we would like to reopen the regulations, make sure we define it all, and then clarify again when you take things that are offered by the approved providers we're going to have to clarify in the regulation. Again, this is for the purpose of your practice as a speech language pathology assistant and not as part of your attempts to get into a master's program.
Sure.
Which of course all gets fettered out when we're in the audit process. So.
That's well said. Any other board discussion? Okay, I'd like to ask for a motion regarding moving to include the legislative proposal as part of the board sunset as
Amended.
noticed. Oh, amended, thank you. Because we made that
Dr.
change. Because we made that change.
White, I will move to include the legislative proposal as part of the board sunset as amended.
May I have a second?
I'll second. Tamara Chambers.
Thank you. I'd like to open for public comment at the on-site locations. There are no members of the public present here at the Glendora location.
At the City of Industry location, there are no members of the public.
And at the Sacramento location, there are no members of the public.
Thank you. I'd like to ask the moderator to open public comment on WebEx at this time.
We are open for public comment on agenda item 11 and the motion. If you'd like to make a comment, please raise a hand by tapping that hand button at the bottom of the screen. Dial-in users dial *3 to raise your hand, and we will call on people in the order we have requests. We're going to take a few seconds to see if we have a request for public comment. Seeing no request for public comment, do you wish to continue with the motion?
Yes, please. Thank you. I'd like to ask Ms. Burns to conduct the roll call vote.
Absolutely. Ms. Dominguez,
Aye.
Dr. White,
Aye.
Mr. Borges,
Aye.
Dr. Chambers,
Aye.
Mr. David,
Aye.
Dr. Sanders,
Aye.
Ms. Chang.
Aye.
Motion passes.
Thank you. Moving on to agenda item 12, discussion and possible action regarding proposed amendments to obtain statutory authority for implementing a retired license status for board licensees. I'd like to ask Ms. Burns to present information on this agenda item at this time.
Yes, so at our May 2025 board meeting, we discussed the possible action to create a retired license status under the Business and Professions Code. There currently was a generic Business and Professions Code section 464 that would allow you to go ahead and promulgate regulations, but you had to follow that statute, or seek authority through our Practice Act using the Sunset Review. So after considering all of the options, the board licensees would have to request being on retired status, and we would have to set the criteria. Because we didn't want to use the generic 464 criteria and the board wanted to use those that it discussed at the May board meeting, we're going to continue with the board's seeking statutory authority to do its own retired license with its own criteria. So the concerns were about how long should they be allowed to be outside of into the retired status before they come back, how many times they can come back, whether or not they can have charges pending against them, or discipline pending as well. And then also how to come back if you needed to, and how to restore that license. So some of the questions, the language that's part of the attachment, it does not have underlines because this would be an all brand new section. So it seems silly to underline the whole thing. It just makes visual distraction. Most of the retired license fees are about $75. It's really just to cover the cost of a licensing analyst processing it and an enforcement analyst doing an enforcement check to make sure we don't have anything pending. And then they would go into that retired status. They could not be suspended, revoked, surrendered, subject to disciplinary action, have an accusation filed against them, or where did it go? I lost my thought there. Or confirmed by an internal investigation report signed by the executive officer to be under investigation by the board. This is a provision that is in one of our other sections, and it seemed worthy of including it. Oftentimes, investigations can take quite a long time. It would be it would be very odd for the board to have someone who's been under investigation but has yet to have an accusation filed to let them retire as if they're in good standing when we have an active investigation against them. So those were our caveats. So that is more restrictive than what the broad statute allows. So we would want to seek our own. We settled on that they can reapply once to restore their license, that they have to have not committed any crimes. They pay all the renewal fees that would be delinquent. They would complete the continuing education. They would also comply with fingerprinting requirements. Due to how long ago some people were licensed, they may not have been live scanned. So they would have to come back and get live scanned if that was part of it. And then the retired license was issued less than 3 years from the date of issuance of the retired. The retired license, there's two provisions. I've seen in some of the other statutes, they have a secondary provision, so it's within the 3 years, or it's more than the 3 years, but they've been continuously maintaining a current, valid, active, and clear license in the same profession in another state. So essentially, they retired in California because they've been practicing in Virginia for the last 10 years, and now they want to come back. So they are not actually outside of practicing the profession. They've been maintaining their CEs, most likely to the national standard, for all of those years. It's an option. So our discussion questions for today, and if you agree with it, that's where it would go. Should a licensee on retired status for more than 3 years, who's been continuously maintaining a current, valid, active, and clear license, and remember, clear means they're not under discipline, in the same profession in another state or U.S. territory, be allowed to reinstate their license to active without retaking any examinations and reapplying for initial licensure? This is most impactful for those that are dispensing hearing aids, because after those 3 years, if you come back, you would have to take the dispensing exams related to your license again. If you were doing the same profession and continuing to dispense hearing aids and provide dispensing audiology or hearing aid dispensing services in another state, we see this occasionally, and unfortunately, those people are stuck. They will have let their license lapse. They can't retire right now, but in the future they could. And they would retire that license, be gone for 10 years, and then surprise, they're now divorced and need to come back. And now they need to reapply and do all of the provisions over again, even though they've been actively practicing and not restricted or disciplined in another state. So I'm putting the question out there. There's a couple other boards that have it. It's an option that's out there. The second question, should a licensee on retired status be able to use this title retired or abbreviations denoting retired license, or are there other ways of denoting the retired license? Because oftentimes people will want to put it on something. I'm a audiologist retired. They might also, I've seen emeritus and other things. So the question mark is oftentimes, can you still use the title? Yes, but it has to have retired following it. So you can say speech language pathologist, comma, retired, those kind of question marks. It only comes up as we look at other folks and what they're doing. So those are the two questions we have for you. Everything else is just what you asked for last time. But those are the two parts that, in our review of all the other boards that have these, those were the two kind of outliers of maybe we should bring that before you ahead of time and see if we can't just include it all in one.
Would you please remind me the difference between an inactive license, like if I select inactive versus retired?
So inactive means I'm not practicing at the moment. In order to reactivate, you have to pay all renewal fees and have one round of continuing education. But inactive, you're still paying the same license fee every renewal cycle. Retired, you would pay one fee and then you would not be paying anything for years to come. Some have been staying inactive and continuing their CE. They either just really love the profession and doing CEs. Oftentimes they want to maintain their national certification. Some think that they're coming back after 10 to 15 years. It's up to the individual. Most often, our problem when we're auditing is people don't know that they can be inactive. So they've been retired for years and they're not going inactive. If they had retired, they probably would have retired, but they don't currently have that option. This would give them that option.
I guess I'm wondering, like, if I were to move to Colorado because whatever reason my family needed to move, I would I would want to keep my California license current, or maybe I guess I could choose to go inactive or retired. But if I'm, of an age where I'm nowhere close to retiring, I've just moved out of state, what benefit? It sounds like I kind of get a benefit if I call my license retired, even though I have no intention of actually being a retired person. I've just left the state rather than going inactive because I have to pay fewer fees.
You do, you pay with fewer fees, but
I don't have to keep my education up.
oftentimes they're keeping it up anyways, just maybe not to our standard. But the other problem being inactive is the same fee as active. So there is, that you're continuing to accrue the higher level of fees. So yes.
So therein lies the rub for me, the sentence you just said, not up to our standard. And that's why I have a concern. So if they leave the state and they're retired for more than 3 years, say they're gone for 10 years and they come back. And if we're saying, okay, you can deactivate the retired and just start again, essentially what we're saying is we have reciprocity with that other state. Right now, if someone has a license in another state and they come to California, they've got to get a temporary license, they've got to pass our tests and all of that, right? So
This person would have already passed it.
they would have passed
whenever.
years
ago,
right?
Years ago.
And they haven't maintained any of their continuing education,
Potentially.
And so then we're saying, okay, now you can come back and we'll just give you a pass. You don't have to retest because you did take the test however many years ago that was.
If they stayed inactive, they could always just reactivate it. It's really a question.
Right. Again, because it's the benefit, right? If they go to inactive when they move away, they've got to continue to shell out all of the money and everything. Whereas if I just say I'm retired, that basically puts everything in stasis, right? Essentially, it's told until they come back and then they say, okay, reactivate me. I'll pay my fee, right? Whatever the renewal fee is, and I just keep going.
I think we said they have to do something with education.
But
They have to make sure, we'll audit them to make sure they have the CE for the full renewal cycle.
for that one renewal cycle,
the one,
yes.
That's what
But, doing a CE is not the same thing as practicing in the state.
Which is different than other states. I will give you that.
Right.
The question mark was, do we want to allow it or not? And that is always the tough question. Some people move out of state and think they're never coming back. And then when they come back, it's a difficulty.
Yeah.
If you think you're coming back and you just went to Colorado and you think, oh, I might be back in 5 to 10 years, I don't know, you could stay inactive the whole time.
Right.
If you think I'm never coming back and then suddenly life changes and you want to come back, usually there's family status changes that go with this conversation. And then they're heading back and they're reorganizing their life. Right now they have to retest.
But not if they stayed inactive.
Not if they stay inactive.
Right.
But if they retired and maybe they left when they were 40 thinking I'm retiring out here and now they're not. So it's
But
just a consideration.
that person wouldn't have to retest if they were marked as inactive.
Exactly.
As retired status. They wouldn't have to
if you allow that
retest as this stands right now on paper.
And nor for inactive.
Yeah. Well, inactive's always been that way,
right.
So that's not going to change. We're basically carving out an exception, a retirement exception, so that those people have the option.
If they only retired in California and they maintained those years, all of those years, they had to stay active, cleared license, doing the same
in another state.
In another state.
Right. They can't just retire and then come back 5 years later having never done anything.
Because that's the question mark. People are more mobile. Will they go?
Okay.
Can they come back? It's up for board discussion. We saw it in some of the other boards. It's not in every other board's retired license status. So it's just one of the options to consider.
Okay. Well, the fact that they're still having to actually practice on a continual basis, I feel a little bit better about that. So it's just
the inactive they don't.
Reciprocity. Right. So that's already there.
It is.
So
Yeah,
I-
inactive is in existence now.
I win the lottery. I go to Hawaii for 10 years. I don't do anything but sit on the beach. I go inactive and I can just come back.
Yep.
I haven't
You-
seen
you-
one patient.
Well, no, but
I've
you
done
have
like
to
10
maintain,
once a year.
you have to maintain your CEUs.
That once, but I don't actually have to practice.
Right.
And then if I retire, I do the same thing.
Correct.
But I do need to be practicing.
Yes. I would tell you though, most people that think their life circumstances change suddenly fall off our radar, and then when it changes again,
Like you said, well, money.
they're really disappointed they found out they can't.
That's a given.
Oh, yes, I have just a comment. Are we considering their status before going into retired status? For example, they are inactive or suspended or expired. Are we considering that before reinstatement of another license?
This statute, if we ask for it, would only allow them to retire when they are already in a clear and active status. So they have to come back. Let me double check myself. Yeah, that is current and active or okay, we allowed inactive. And those whose license is not suspended, not revoked, not surrendered, or subject to discipline or under investigation.
And just
So-
for clarification, when we apply for a retire, when is it time to apply for a retired status?
In
When-
this one, it would allow inactive. Many of the folks that are currently not practicing would be in inactive status. Those that actually have retired in 5 to 10 years. They've still been paying their inactive dues. That would allow them to also retire. There are some statutes that only allow active, so the person would have to come active again in order to retire. That is an option as well. I don't know how great it is for those that have just been sitting and waiting for us to get a retired license status, so they've been inactive for the 10 years they've been retired.
Seems like an
But it-
unnecessary hoop to jump through.
It's either way a
Inactive.
clear license. It's clear and inactive or it's clear and active.
Prior to the retired status.
Yes.
Just
And
clarification.
not under investigation. So again, the website might say clear, but if we have an active investigation that I certify an investigation report for, then you also could not just enter retired status.
Okay, thank you for the clarification.
It's almost kind of a how to define our good and clear standing.
And is that all listed under the criteria?
Yes, it's
All of
in
that?
subdivision A.
All of it, okay, including the inactive.
Yes.
Thank you.
So really it becomes questions of, do you want to allow inactive? Do you want to allow those that have been practicing in other states continuously to have that avenue back in? And then also the question about using the retired abbreviation.
So really, it's not really retired though, right? Because they have to still be working
For some, it's not.
at the same, but I guess they'd only have to still be working if their intent was, I want to
I may want to
create
come back.
a back door to come back in. For those that are literally retiring, it doesn't really matter.
Most of
I
them
don't
retire in
underst-
state.
Yeah, I don't understand. Well, I guess I understand the point of the retired status for those that are actually retired, if they're not planning on ever.
I would tell you there are
I guess it gives the option of going one way or the other.
there are a significant number of licensees who I've spoken to that have been in, well, they should have been inactive for the last 10 years, because they've been retired for 10 years, but they were active, so we audited them. Because I guess some people think inactive is a delinquent type of status, which it's not, it's just not practicing. But those folks have retired, they're still in the state. Interestingly, they're still giving up their CE, but only to the national level. The other ones, oftentimes, we find them when they're coming back. They currently don't have an avenue, so they unfortunately are asking how to get back, how to become active again. And unfortunately, many of them are going to have to re-exam, start all over.
Yeah, I think
Even though they've been
Okay.
practicing in that other state
Right.
for those years.
some people have like a negative connotation to the word inactive. I don't
Yeah.
know why.
I still
Um,
don't understand that.
Yeah, and to the second question, I think, I wouldn't recommend an abbreviation. I think if they want to comma retired is totally fine.
Yeah.
But maybe people know what RET dot would mean as an abbreviation, but I think just saying retired is probably the better choice.
So you're saying you're okay with having, with using a title retired?
Sure.
Okay.
I mean, that's the second question they're
guess.
asking.
Yeah, right,
And
right.
I imagine it's in here as a question because it's been asked.
Right.
It has, and other boards have had to struggle
Right.
with it.
Rather than saying inactive, I
Yeah.
can say
Retired.
Amy White retired.
Right. Yeah.
Like-
I mean, I guess I don't understand the need to actually
why.
have that after. Yeah, I mean, I'm not in the military. I'm not a general retired or anything like that. So
Yeah, it's
I don't
it's the only
understand.
other time
I don't understand the need or the purpose of having to have to title yourself as retired.
It's important.
But-
It's,
Okay.
yeah. So if I say audiologist retired, because I can't say I'm an audiologist if I'm not in an active license.
Right. Well,
But I still want to say I'm an audiologist. Maybe I'm presenting and I want to say I'm an audiologist, but I need
Right.
to say I'm a retired
right.
audiologist.
So instead of just telling everyone I'm a retired audiologist, you would say I'm an audiologist retired.
Yep.
Okay.
I mean, under your name, right?
Right,
The-
like on a business
credentials,
card or
yeah.
something.
Uh-huh.
like that.
Oftentimes, somebody
Yeah.
might present and say, I'm an audiologist, but if the board finds out you're advertising as an
Right,
audiologist, but
right.
you're not licensed, then we have a
Right.
different problem.
Right.
And
Okay.
Amy's point, the presentation, you're titling
Yeah.
yourself at the beginning of that presentation.
Right,
Until
like
you bring
giving
your
a talk
talk
or
or establish, you still
continuing it.
conduct research, you can still present that research, share with all sorts of things while you're not practicing.
Right.
I'm okay with as presented here. I don't know if anyone else has other opinions.
Yes, I am too.
Same.
Given the fact they have to maintain their, they have to be actually working in order to maintain that, then I'm okay with it.
I otherwise would not have
Yeah.
either.
Yeah, that's an important distinction.
Yep.
Yeah, I'm okay with it as long as they have to be working still in order to maintain that title.
That's easy to bake into the application, so.
Okay.
Okay. Is there any other board discussion before we move for asking for a motion? Okay, I'd like to ask for a motion on this agenda item, and there is suggested motion language on the bottom of page 2 of 2.
This is Dr. Sanders, and I move to adopt the legislative proposal to be included as part of the board sunset review as noticed.
As Dr. White, I'll second.
Thank you. I'd like to ask for public comment. We'll start with the on-site locations. There are no members of the public present with us at this time.
This is a City of Industry location. There are no members of the public with me at this time.
This is the Sacramento location. There are no members of the public present at this time.
All right, thank you. I'd like to ask the moderator to open public comment on WebEx at this time.
We are open for public comment on agenda item 11. If you'd like to make a comment, please raise a hand by tapping that hand button at the bottom of the screen. Dial-in users dial *3 to raise your hand, and we will call on people. My apologies. Agenda item 12. Regardless, we are open for public comment. Please raise a hand by dialing *3 or tapping the hand button at the bottom of the screen. We're going to wait just a few more seconds to see if we have a request for public comment. Seeing no request for public comment, do you wish to continue with the agenda?
Yes, please, thank you. I'd like to ask Ms. Burns to conduct the roll call vote at this time.
Absolutely. Ms. Dominguez,
Aye.
Dr. White,
Aye.
Mr. Borges,
Aye.
Dr. Chambers,
Aye.
Mr. David,
Aye.
Dr. Sanders,
Aye.
Ms. Chang,
Aye.
and the motion passes.
Thank you. Before we proceed to agenda item 13, we will go ahead and take a 15-minute break at this time. We will reconvene at, give it an extra minute, 10:41.
Are you going to take me to Hawaii?
Then I just go and act. Pay all the money.
Well,
Correct.
part of the
Because I have
disconnect
in my,
in my
that's how I
brain
lost all the
comes
money
from
for paying.
understanding the
Correct.
word.
We can still hear you.
Board office.
We can still hear you. Thank you.
Yeah.
Okay, good morning. We are ready to return from our recess in our board meeting. We'll reconvene and move to agenda item 13, discussion and possible action regarding technical statutory cleanup. And I'd like to ask Ms. Burns to present information on this agenda item at this time.
All right. So each year, the Joint Sunset Review Committee is a committee of the Assembly and the Senate combined. They hold joint sunset review oversight hearings to review boards and bureaus under the Department of Consumer Affairs. So our board 4 years ago went up for sunset review. We write a very long, detailed report about what we've been doing over the last 4 or 5 years, or however long the time span is. There was a momentary pause during COVID where everybody got a little bit longer. And we go back up for essentially renewal. We get renewed as a board for another 4 years if we're doing our job and we are doing it well. And part of that report includes technical cleanup. So normally we come before you at the last meeting of the year and we talk about an omnibus proposal. That's an annual Senate-driven technical cleanup item. Sometimes instead we want to include it in our sunset. And that could be multiple, a big slew of them. They could be ones that over time, we keep looking at different statutes and we say, okay, yeah, let's make sure we clean up this one. Sometimes in order to clean up 1 or 2, you also need to clean up 3 and 4. So when we looked at the hearing aid dispensing and when is it a licensee versus should it be a hearing aid dispenser when we're talking about a branch license, right? It shouldn't say licensee, which means technically the other 2. Even though another section says, no, you can't. So part of cleanup is kind of discussing all those issues. The purpose is, of course, to get this going as part of our sunset review, which will be next year. We will go before the legislature, the board chair and myself, and testify and bring the nice, fun 200+ page report. And this would be included in it. These are mostly all very non-substantive technical cleanup items. There is a long list of them. I'm not going to go one by one. What I will tell you is they do not include those that are separate, including changes to the CPD for speech language pathologists and audiologists, changes to the CPD for the speech language pathology assistant. It also does not include the hearing aid dispenser duplicate and branch office, since we're going to talk about that as an issue and talk about all of those in one. And it's also not going to include the retired license status because that's not technical cleanup. Now, the biggest ones in here are changing things. So like if you look at page 1 of 27, we've struck out limited liability company on here because we don't actually allow limited liability companies when it's speech language pathology or audiology. There's a separate section where you either need to be a partnership or a speech corp or an audiology corp. There are already provisions in that. It's slightly misleading that limited liability company would be allowed. It's old language. The board doesn't allow it. Just go ahead and remove it so it's clean, because we do have a number of people that we are working or going to be working with who have limited liability companies in speech or audiology that now need to move to corporate. So part of cleaning up the statute is to also, again, get rid of extraneous language that isn't allowed, and that way it's not confusing. So some of these are to help with confusion. Some of these are corrections such as subdivision F instead of subdivision E. These are all just to make the proper cross-reference. The word wasn't coming to me. Let's see. Some of these are also cleanup provisions on each person holding a license or registration under this chapter shall display it conspicuously at their primary place of practice or business. Putting everybody on the same level of we all display our licenses, we all have a notice to consumer. Talking about the aid and the speech language pathologist, I'm on page 7 of 27 if everyone's following along. This is to make it clear, since it would be a conflict of interest for you to employ your supervisor, that a speech language pathology aide or assistant cannot be the sole proprietor of, manage, or independently operate a business that engages in the practice of speech language pathology. If we know about the relationship, we would never approve the supervision thereof, and that is part of making this clear. So The next pages as we go along, in page 8, it just adds some of the other names for the same master's degree, whether it's speech language pathology, communication disorders, communication science and disorders, communicative disorders, or speech language and hearing sciences. These are all the titles of master's degrees that the board has approved, whether it's equivalent or not, and we might as well add it to the statute so there's no confusion when you come in and have that type of master's degree.
Are we unconcerned about hearing aid dispensing trainees just because it's a temporary thing? Being the owners of a business?
These are all in number order, so I believe we
okay.
get to them later. No
Sorry.
worries. Plus, they already have that they can't manage or independently operate in 30, so I think you're kind of covered.
Yep, gotcha.
So it's just something we noticed on the speech side that we started getting the questions a couple years back, and we keep getting more. So I don't quite know who's purporting this is a good way to go, but it's not, and it creates conflict of interest, and the board will deny it if we find out. So, the next parts are on cleaning up some of the examination language in the speech and audiology sections. It was very old language, some of it talking about oral examinations and other ways of examining. This just cleans up what's already being instituted and puts it in the statute so it's not confusing. If we go on to the next pages, 12 and 13, these are also cleanup items, making sure we say license or registration throughout. When it talks about on page 12, rendering professional services in violation of section 13404.5 and 17701.04, that's the corporations code. So again, we have to follow the Moscone-Knox corporations code section. So most business owners are aware of it, but again, the LLC problem, right? So you do have to follow all those provisions, even if it's not all spelled out. That would help cross-reference it for those people. Pages 14 and 15, again, a lot of adding registrants in here, so that's just cleanup. Also cross-referencing the appropriate sections. When we get to 2535, this is about expiration. We didn't always loop in the speech language pathology assistants or the aides. They just kind of were like not spoken about their renewal. So again, we're making sure we cross-reference all of the license types on the speech and audiology side. The renewal timeframes and things are the same. The system already does that currently. This just puts it in there. 2538.3, it adds the same to those, and that's about a speech language pathology assistant license. Currently, the statute said only speech language pathology or communication disorders. This clarifies these are the other ones that we allow. These are the other ones that should be allowed for SLPAs as well, so it's all the same. So those would be when they're applying with a bachelor's degree rather than approved SLPA program at the community colleges. On page 17, this is talking about the utilization of a speech aid in school districts. We often have to cross them over to other statutes to again remind them that you can have a speech aid, but they cannot be performing the duties of a SLPA. They have to be doing the duties of a speech aid, even if it's in your school. So you can't just say pound sand, Board of Speech and Hearing. You do actually still, if you're going to offer speech language pathology assistant services, it needs to be by a licensed speech language pathology assistant. We kind of stay out when it's their aides because, again, we only register aides if it's to our speech language pathology licensee. So not if they're a CTC holder only, which is the California Teacher Commission credentialing. I said it wrong, but you know what I mean. So the other ones are about speech language pathology assistants, shall not advertise or otherwise represent that they hold a license as a speech language pathologist. It seems clear, but we just want it to be clarified. Again, you have title protection, so SLPAs can't do that. It's kind of just stating it in that own section, so it's clear. And let's see, then we get into the hearing aid dispensing sections, 2538.10. So a license, when we're talking, means a license to engage in the practice of fitting or selling hearing aids to an individual or individuals with impaired hearing. Talks about the difference between license, licensee, hearing aid, so forth. mostly just to clean up the way they were kind of wishy-washy talking about licensees throughout that section. Again, it's clarifying in each section, whether it's just the hearing aid dispenser it applies to, or is it all licensees, including the temporary and the trainee. Let's see, hearing aid dispenser, we go ahead and make sure that means a person issued a permanent license pursuant to this article. So again, when we say it, we mean the hearing aid dispenser. When we say all licensees, we mean hearing aid dispenser, temporary, and trainee. That way it's clear, they're all separated out. And in, let's see, in 655.2, as well as section 13404.5 and 17701.04 of the Corporations Code, all of those are the exclusions that say who cannot hire who and employ who. Oftentimes people get confused, so it's just cross-referencing so everyone's aware. All of these still apply, and that's why it says except for what's obligated in there or prohibited in there. Sorry. So those are all non-substantive. Pretty much legal has often confirmed that our provisions about selling hearing aids via catalog is the same as selling them online. This puts in there online so that it's clear. That way there's no more confusion. The other ones are making sure oftentimes it would say chapter instead of article, and you are all now under the same article, so that helps clarify it's not just that chapter. Mostly just dealing with what are we referencing. And then we go on to page 21. Again, when it's licensee, it's for all of them. When it's hearing aid dispenser, it's them. This is clarifying all the requirements we currently uphold already, but making it clear who's assigned to what. On page 22, we talk more about those. So when to renew an unexpired permanent license, instead of the licensee, it has to be hearing aid dispenser, because again, when we're talking about these renewals, it's for the hearing aid dispenser because the temporary license is not renewable and the trainee license is separate. And that way it's making it clear. And when we talk about duplicate, it's got branch office. When we get into the 2539 section, that's for dispensing audiologists. We're removing the old clause about on or after January 1, 2010. So everybody's pretty much good. We don't need old language that keeps an old date for no longer grandfathering purposes. So those are clarifying that. Moving on to 24, again, these mirror the hearing aid dispensing side, right? Online as well as catalog, same thing. Let's see, when it talks about audiologists, making sure it says dispensing audiologist in all of this section so that it's clear. Again, this is you've got a separate class on your license, it's for the dispensing audiologist. And then making it clear the exceptions when you get to page 25. So a dispensing audiologist who satisfies the requirements of 2539.1, which means you've been licensed to be a dispensing audiologist and not just a regular audiologist, that you are authorized to sell hearing aids pursuant to the requirements all in Article 8. And B is the exclusion that dispensing audiologists are exempted from subdivision B and C of 2538.11. That's current statute. And the provisions of 2538.12. That's current. We're just making it clear that, hey, in case you missed it, you are required to follow all of the dispensing requirements, which you've been held up to the whole time, except for those. Now, when you get to page 26 and 27, the dispensing audiology license has been operating this way. You've been renewing annually. You've been following the renewal requirements of 12 instead of 24. You've been renewing annually instead of biannually. Most of these are all just to go ahead and clarify when those are happening and how it changed with your renewal cycle. So again, when you're a dispensing audiologist, if you decide not to renew after 3 years, you can't just reactivate as a dispensing audiologist. Your audiology license is still available to reactivate, but again, after the 3 years, because you're on an annual renewal, that's the problem. If, however, you're a dispensing audiologist after 3 years, the dispensing will fall off. You will still be an audiologist, but if you surpass the 5 years, again, your license will cancel. So it keeps it all clear that just because you lose your dispensing because you went expired for 3 years, you wouldn't lose your audiology, but essentially making clear how everything operates right now and putting it in the statute. And that is all of the variety of changes. Many of these we've been accruing for the last 4 years and just keeping a tab on. And some of which, when we asked to clear things up in a prior omnibus, they said, well, wait, what about for hearing aid dispensing? But it says licensing here. Or, hey, your exams, do you still do an oral exam? I'm like, oh, wait, hold on. We need to fix all of that because we don't do any oral exams anymore. Audiologists take the praxis in audiology. Speech language pathology takes the praxis in speech language pathology. We do not offer oral exams, and so on. So those are all the technical cleanup changes that the board is proposing.
I just have a quick question. I didn't want to destroy your rhythm.
No worries.
So I wanted to tell you, just at the beginning, just for clarification, where you're removing limited liability company.
Mm-hmm.
So myself as an individual that wants to sell hearing aids, I cannot create my company as a limited liability company and fit hearing aids, but I could go to work for a company that is a limited liability company and fit hearing aids.
This section only applies to speech language pathology and audiology.
Oh, okay. So that doesn't apply.
Yeah, you guys are kind of a separate entity.
All right, cool.
Because we have speech corporations and audiology corporations on that side, we have to have separate rules. The board has not looked at and didn't really have any intentions to look at the corporate structures involved with the hearing aid dispensing side that have never been included in the Moscone NOC. It's just something that's always been outside of it.
Thank you. Just wanted to.
Yep.
But
yes, that section is only for audiologists and speech language pathologists.
Perfect.
I have a number of just small, like typo-ish corrections. Do you want me to run through those?
Oh, I so do. Hold on a second.
Okay.
Because I'd much rather catch them now than when the legislators catch them. Go ahead.
All right. So on page 4 of 27, second line from the top, I think the comma between auditory training and speech reading is confusing. So either take away the comma and say auditory training and speech reading, comma, and the selling and fitting of hearing aids, or take the and before speech reading out. So either remove the comma or the and, one or the other.
I'll take out the and.
Okay.
Okay.
And then the next line down from that, a dispensing audiologist is.
Oh, we lost the first A part.
Exactly. And it should be AN, yeah. An audiologist.
Yep.
And then the next page, page 5, the very bottom, E. Do we need to add audiology extern into that? Because you're specifically calling out services of a student or audiology intern.
No, because this is separate about students and audiology interns. Audiology externs are covered under RPEs.
RPEs. Okay. Thank you. Just to clarify. Then on page 10, A, third line down, it shall examine the applicant with regard to theirs misspelled.
Ah, thank you.
Yep. The right there, just the wrong letters in the letters in the wrong order.
And it wouldn't catch it because I've already got other things screwing up the spell check.
Yep, and then we have the exact same problem with there on page 18, the very last paragraph, second line.
You get there.
Their education after receiving their license. Yep. And then lastly, on page 25, this may not be I'm not sure what kind of problem this is. So I'm misunderstanding maybe what I'm reading. So under the section 2539.8, so it says no hearing aid shall be sold by an individual licensed as an audiologist under this article to a person 16 years of age or younger, unless within the preceding 6 months a recommendation for a hearing aid has been made by both a board certified physician specializing in otolaryngology and by a state licensed audiologist. an audiologist can't sell a hearing aid until another audiologist that's state licensed says they can sell a hearing aid to someone under 16?
My guess is that's because they copied it from the 2538 section and no one caught that it has the restriction in here. And that's an oopsie.
Okay.
Because that's all current language. I'm not amending that part. That might have to be separated out as well, it's not really, it's still a cleanup issue.
It's just like dispensing audiologists.
Yeah.
So we're saying, okay, so what we're trying to get at there is saying an audiologist, I mean, we already know a non-dispensing audiologist can't sell a hearing aid anyway.
Yeah.
So what exactly is this saying?
I think it is literally just a repeat of the 2538 provision of the same. Let me look before.
Yeah, it is. I'm not sure if it was discussed like a dispensing audiologist is also an audiologist. But yeah, it's a repeat from what's in the article for hearing aid dispensing.
I had a question on that too. Can you clarify how that should read?
I mean, I actually,
I'm not sure.
I don't know what I want to say, and maybe I shouldn't out loud. It would be news to me if an audiologist, a dispensing audiologist, couldn't fit a child under the age of 16 without additional. And
I think that's just an oopsie when they created the dispensing.
It's usually hearing aid dispensers. Section. Yeah, hearing aid dispensers have that limitation.
They just literally cut and pasted 2538.37 in there. Yeah, and that's an oopsie.
Okay, so the whole thing really just shouldn't be in there, right?
I think so, because at the time they were making the copy, you were having audiologists who had a separate hearing aid dispensing license switching over, and now we're all part of one, and we no longer have that problem with the dual.
Right.
So I think we would want to wordsmith ways to make that clear. Because we're saying unless your audiology license has a dispensing, then you can do this. I don't even know if you did.
No, it sounds like
I think the whole thing shouldn't be in there.
So yeah, that sounds like that we would have to remove that whole thing and then maybe add in the exemption in 2539.4B that doesn't apply.
2538.37 is also an exclusion.
Yes. $2538.37. So then we would strike through all of 2539.8. I enjoy that we've been a combined board for many years and we've noticed that. And then in 2539.14B, we would add the provisions of subdivision B and C of section 2538.11, the provisions of section 2538.12, comma, and provisions of section 2538.37 do not apply to a licensed audiologist who satisfies the requirement of section 2539.1, which means you got your dispensing audiology license. That would make it clearer. There you go.
That's all I have on edits.
Great, when one cleanup can trigger another. Any other edits? Anyone else caught any typos?
Yes, we have a comment here.
One additional question on page 23 of 27.
Okay.
When it's BPC section 2539.1, when you go to B, the end of where it's all everything has been striked out, it says this paragraph shall not prevent an audiologist, but the paragraph is gone. So is there still a need for that, or does it need to be condensed, or is it obsolete altogether?
You need to keep it, but you don't need this paragraph.
There's that last sentence. I'm not sure, I'm not too familiar with the licensing of how it works in the system, but the last sentence says this paragraph should not prevent an audiologist who has a hearing aid dispensary license from maintaining dual or separate license if they choose to do so. But I'm not sure if that's currently if that's an option still available with.
It is still available, and it's
Mhm.
really just a grammar thing. It's not about this paragraph. It's just that the board shall not prevent an audiologist who has a hearing aid dispensary license from maintaining dual or separate licenses if they so choose. If you really want to pay both of them, we are not going to complain to you, and you can keep them separate. It is interesting, but there are some that still wish to do so. So we don't want to prevent them from doing so, but it doesn't need to say this paragraph. It could actually say the board shall not.
Thank you.
The
And
board
then
will,
how is it numbered? Will it still be B?
it would still be B. It would just say that the board shall not prevent it.
Okay.
Right now, most audiologists would prefer that we just combine and make it a dispensing audiologist license instead of keeping a audiology license and a separate hearing aid dispensing license. But we do let them do that. There are currently two separate agency systems, so the system has to have, we never combine systems, and so it is possible for the system to keep them in two separate categories with two separate licenses. Again, you'd be paying for both, and you would be maintaining continuing education for both, but that's up to you. I'll leave that alone. Thank you, Dr. Chambers.
Thank you.
All right, I don't have the visual cue. Is there any other just board discussion on this agenda item? Okay, great. Hearing none. I'd like to ask for a motion. There is suggested motion language on page 4 of 4 regarding including the technical legislative cleanup as part of the board sunset as amended. I'd like to ask for the motion.
This is Karen. I'll move to include the technical legislative cleanup as part of the board sunset as amended.
Can we get a second?
This is Todd, I second.
Thank you. I'd like to move to the on-site locations regarding public comment. Here at our Glendora location, there are no members of the public present.
At the City of Industry location, there are no members of the public present.
And at the Sacramento location, there are no members of the public present.
All right, thank you. I'd like to ask the moderator to open public comment on WebEx at this time.
We are open for public comment on agenda item 13 and the motion. If you'd like to make a comment, please raise a hand by tapping that hand button at the bottom of the screen. Dial-in users dial *3 to raise your hand, and we will call on people in the order we have requests. We're going to take just a few seconds to see if we have a request for public comment. Seeing no request for public comment, do you wish to continue with the motion?
Yes, please, thank you. I'd like to ask Ms. Burns to conduct the roll call vote.
Yes, Ms. Dominguez,
Aye.
Dr. White. Aye. Mr. Borges,
Aye.
Dr. Chambers,
Aye.
Mr. Francis, Mr. David,
Aye.
Dr. Sanders,
Aye.
Ms. Chang.
Aye.
And the motion passes.
Thank you. Moving on to agenda item 14, discussion and possible action regarding Audiology Practice Committee recommendation regarding consumer protection and licensing issues related to potential creation of an audiology assistant license type. I'd like to ask Committee Chair Dr. White and Ms. Burns to present information on the agenda item.
Want me to lead? Sure. All right. So the board received the letter attachment A from the California Academy of Audiology to open a discussion with the board on the possibility of creating a new license type for audiology assistants. At its October 2022 meeting, the board discussed and reviewed the Sunrise process and delegated it to the Audiology Practice Committee to provide the board with a recommendation. The committee did that in the May 2025 meeting, where they discussed and reviewed the Sunrise process, which is a statutorily required process if a board wants to create a new license type, to determine whether it was an appropriate action for the board to take to create an audiology assistant license type. The committee also looked at an alternative action to create this license type, such as a professional association seeking a state assembly or Senate member to author a bill to create the license type. That would be similar to how the speech language pathology assistant license type was created. Do you want to give the determination?
Sure. So ultimately, we did determine as a practice committee there just wasn't enough reason in terms of what the board is responsible for doing to pursue the license category. And so we declined to take this up under Sunrise to create this license type. That said, the committee is supportive of the license category being pursued. And so today I also would like to ask our board here to take a support and concept position for the idea of the association to work on an audiology assistant license category, and to direct the board staff to assist with technical support for them where able.
All right, thank you for presenting that information. I'd like to open it up for board discussion.
I'd like to know if it would be appropriate, since we received a letter, to respond with a letter stating what Dr. White just said.
We can do that. We can be formal and provide a letter.
I think that would be appropriate for them to really showing the board support and having in that letter stating that the board staff can offer them logistical support in the creation.
I'm going to take your recommendation to write the letter at the moment and leave it up to the board and making a motion on whether or not to support and direct staff. But the letter as a response, absolutely noted.
Is there any other board discussion? Okay, so hearing Ms. Burns's statement, moving forward to ask for a motion to support and direct staff to provide a response letter. Would the office staff like to provide any type of recommended language, or committee chair, Dr. White, do you want to initiate the motion?
Sure. So I would make a motion for the board to take a support and concept position for the idea of the associations to work on an audiology assistant license category, and to direct the board staff to assist with technical support where able.
Okay. And that includes responding with a letter, correct?
Yes.
Okay.
Dr.
Do we
Sanders?
have a second?
I second.
I second it.
All right, thank
All right.
you.
Dr. Chambers beat you to it.
Oh.
All right. Okay, we'll move on to public comment. We'll start with the on-site locations. There are no members of the public present here at this time.
This is the City of Industry location. There are no members of the public here at this time.
There are no members of the public at the Sacramento location at this time.
All right, thank you. I'd like to ask the moderator, open public comment on WebEx at this time.
WebEx is open for public comment on agenda item 14. If you'd like to make a comment, please raise a hand by tapping that hand button at the bottom of the screen. Dial-in users dial *3 to raise your hand, and we will call on people in the order we have requests. And it looks like our first request is coming from Marcia Raggio. Hold on just a moment. We're going to send you a request to unmute your microphone. You'll be given 3 minutes to speak, and I'll give you a 30-second warning before your time expires. All right, we're going to try again. We're going to see and send an, oh, I see you're unmuted. Marcia or Marcia, are you with us? Let's try again. Hold on just a moment, please. We're sending you another request to unmute your microphone. And I'm also going to display a slide that might help you. Bear with me just a moment.
How about now?
I hear you.
Okay, sorry. Okay, this is Marcia Raggi. I'm the Northern California Legislative Liaison for the California Academy of Audiology. And I just wanted to say that after our discussion in May, the Academy took it to heart what you had said about us taking the lead and trying to find a legislator, or write a bill, and so on, and pursue this license change that way. So that is what we are starting to do. That we're going to start it in earnest in September in that effort. But our Sacramento advocates, Nick Brokaw, had said that we really need the support of the board. If we don't have your support, we're not going to get very far. So I'm just laying that out there, that going forward, we hope to have your support. We'll supply you with any information that you need in terms of our efforts and what we're saying, so that you can see whether you can or can't get behind it. But hopefully we're going to work with you as we go along so that you're able to. Thank you.
Thank you. And that was our only request for public comment.
All right, thank you. We will move forward with asking Ms. Burns to conduct the roll call vote.
Absolutely. Ms. Dominguez,
Aye.
Dr. White. Aye. Mr. Borges.
Aye.
Dr. Chambers.
Aye.
Mr. David.
Aye.
Dr. Sanders.
Aye.
Ms. Chang.
Aye.
The motion passed.
Great, thank you. Moving on to agenda item 16, discussion of the February 2025 occupational analysis of the speech language pathologist profession. I would like to know.
We missed 15.
Oh, we missed 15. Oh, sorry about that. Okay. All right. Thank you.
We do appreciate you trying to expedite it, though.
Okay, moving on to agenda item 15, update on Centers for Medicare and Medicaid Services, changes to the interpretation of the Medicare Benefit Policy Manual related to the required professional experience, temporary license holders, treatment of Medicare patients, and billing for services. I'd like to ask Ms. Burns to present information on this agenda item.
Okay, so back in June of this year, the board was made aware of changes to the Centers for Medicare and Medicaid Services interpretation of outpatient speech language pathology services requirements in Chapter 15 of the Medicare Benefit Policy Manual. It's a gigantic manual, so we have provided you just with the excerpt about said changes, and that's in your attachment. And that really talks about who is a qualified speech language pathology provider. The changes to the interpretation of said definition, CMS had interpreted that it no longer included individuals who meet the educational requirements for certification and are in the process of accumulating the supervised experience required for certification or licensure. For this reason, the board and many other entities became concerned that there could have been new billing and supervision requirements for required professional experience temporary license holders in the practice of speech language pathology when it came to the outpatient settings and billing for Medicare. This initially set off quite a panic in the fact that any of the RPEs working in settings for outpatient settings could potentially have to revert to student level supervision standards and not be able to bill Medicare directly, which became problematic for a variety of reasons. And then I think I have June 20th, but I think it's June 25th. But again, as I mentioned in my report, I listened in with other executive officers and representatives at the American Speech Language Hearing Association virtual town hall to discuss these changes. At that time, I brought up that the occupational therapy and the physical therapy were both defined and allowed to have a different set. And so it was an interesting interpretation not to include it like your life professionals. Some of those issues were brought back to CMS by the American Speech Language Hearing Association. They went ahead and continued advocating in order for that new interpretation to change. On July 31st, the board received notification that CMS reversed its previous interpretation, so it's no longer a change. RPEs can still be recognized as qualified Medicare providers. It will not impact our RPEs that are speech providers, and therefore we don't have a concern about that. The board was putting this on its agenda just so that we could remind our licensees that regardless of what CMS or any other billing entity does, the board's supervision requirements are as stated in the memo. Again, that's 8 hours of in-person or 8 hours of direct supervision, 4 hours of which can be telesupervision, and that's if you're full-time. So nothing in ours would have changed that. And now nothing is changing at the CMS level either. So this is just information purposes only. It's in there and no longer a problem. But just in case anyone didn't know, now in our board materials, it is not a problem. Everyone can carry on. And again, the board has specific requirements, none of which would have changed either way that CMS went. And we would remind people, if you are engaged in billing things like Medicare, or you're part of a professional organization where certification is a concern, or other managed health insurance providers, supervisors should provide the higher level of supervision if you're participating with those entities. But again, that's not a board requirement, and they should contact those entities, not the board, about those requirements rather than the boards. And that's it.
All right, thank you. Is there any board discussion? Well, I'm glad that was fixed.
There was definitely no momentary panic.
Yes, for sure, for sure. All right. Okay, hearing no other board discussion, I'd like to open public comment at the on-site locations. There are no members of the public present with us at the Glendora location.
This is the City of Industry location. There are no members of the public here.
This is Sharice at the Sacramento location, and there are no members of the public here.
Thank you. I'd like to ask the moderator to open public comment on WebEx at this time.
We are open for public comment on agenda item 15. If you'd like to make a comment, please raise a hand by tapping that hand button at the bottom of the screen. Dial-in users dial *3 to raise your hand, and we will call on people in the order we have requests. We're going to take just a moment now to see if we have a request for public comment. Seeing no request for public comment, do you wish to continue?
Yes, thank you. Okay, moving on to agenda item 16, discussion of the February 2025 occupational analysis of the speech language pathologist profession. I'd like to ask Ms. Burns to present information on this agenda item.
Thank you. So Business and Professions Code Section 139 and Department of Consumer Affairs Policy requires that the California State Licensing Boards conduct regular occupational analyses of the professions that we regulate as a fundamental part of each licensure program. In addition, the Section 139 NDCA policy also requires a review of any national examination a program uses for the purposes of licensure in the state of California. So we periodically run these. We contract with the Office of Professional Examination Services to conduct these occupational analyses. We do them every 5 to 7 years. Due to cost, we have to kind of spread them out because we have 3 professions, not just one. So again, every so many years we do these. This one is for the speech language pathology profession. OPE has gathered information from literature and telephone interviews and conducted workshops. as well as a statewide questionnaire and survey to identify tasks and knowledge required to practice the speech-language pathology profession in California. The result was the occupational analysis that is prepared and is part of your attachment. It covers all of the process for developing the occupational analysis, the questionnaire and response rate, the rating scales, the list of tasks, and a copy of the questionnaire. Following the completion of the occupational analysis, the list of tasks and knowledge statements can be used to review the national exam, and that's the praxis exam and speech-language pathology, proctored or administered by the Educational Testing Service, ETS. This review is currently underway where they are going to be reviewing the praxis SLP. As we will talk about in a future agenda item, I would point out that linkage is to ensure that the national examination adequately covers California-specific requirements of speech-language pathologists. Every time we do an occupational analysis for audiology and speech, we then take a look at the praxis, so it's the national exam, to make sure it's adequately covered. And then if it's not adequately covered, the board would have to consider, do we need a California-based license exam? For instance, if there was enough California-specific laws and ethics requirements that are different, they would make a law and ethics or jurisprudence examination that's California-specific. Currently, that linkage study is underway. This is a report requested and done under contract with OPEB. It is a report that we will include in the sunset, so we wanted to make sure you all got to see it. And since we were going to be talking about examinations as well, it was a good opportunity to say, hey, we did it. The board did the hearing aid dispensing one back in 2020, but I was too new to realize we probably should have brought it to the board to say, hey, by the way, we've done this study. And here it is. And, oh, by the way, let's include it in our sunset because it's a report that we commissioned to be done. So this time around, you can review it. We'll also include it in our sunset. I can't remember which attachment letter it is, but every sunset they ask us to include any reports or studies that the board has conducted or contracted to have done. This would be included, and we can include it there. Other boards do the same.
How often are these reports done again?
Every 5 to 7 years.
Okay, so the dispenser one is going to be.
Audiology will be next. Audiology's been a while, so we're doing that one next. Due to our budget and the cost of continuously reviewing and updating the written exam and the questions in there to keep it valid, we often are already spending a good chunk of our OPES budget on that every single year. Right. So we have been trying to make sure budget-wise we do this as fiscally conservative as possible. So often we're now trying to say, don't do an occupational analysis in one single fiscal year, please split it in half. And then we need to do them back to back to back almost. So that way it's 2 fiscal years speech, 2 fiscal years audiology. And at that point you then are restarting or about to restart the hearing aid dispensing again. So trying to juggle that and keep it all in context. We should have been doing a couple of these earlier. We just, again, we're doing hearing aid dispensing, didn't have the budget one year. So we kind of have to manage all those things. My hope is to have this more in lockstep. This is how we're doing it. We're spreading across 2 fiscal years, and we're going to keep doing them in succession, and that should keep us on the 5-year program. Max 7. So.
Well, I appreciate your due diligence in distributing this and obtaining the information, doing your data analysis, and presenting the information to us. Are there any other comments from the board? Okay, hearing none, I'd like to open it up for public comment at the on-site locations. There are no members of the public here with us at the Glendora location.
There are no members of the public here at the City of Industry location.
Sacramento location?
There are no members of the public at the Sacramento location.
All right, thank you. I'd like to ask the moderator to open public comment on WebEx at this time.
We are open for public comment on agenda item 16. If you'd like to make a comment, please raise the hand by tapping that hand button at the bottom of the screen. Dial-in users dial *3 to raise your hand, and we will call on people in the order we have requests. We're going to take just a moment now to see if we have a request for public comment. Seeing no request for public comment, do you wish to continue with the agenda?
Yes, please. Thank you. We'll move on to agenda item 17, discussion on hearing aid dispensing licensing examinations as stated in BPC sections 2538.17, 2538.25, 2538.31, and 2538.32, and Title 16 CCR sections 1399.112, 1399.120, 1399.121, 1399.122, and 1399.152.4. I'd like to ask Ms. Byrne to present information on this agenda item. We're not able to hear anything if you're speaking.
Thank you. I was sitting on mute. Apologies.
Okay, thanks.
Starting over. So at the board's September 2024 board meeting, board member at the time, John Dandurand, provided the board with a letter endorsed by the Hearing Healthcare Providers of California Association titled Recommended Regulatory Changes to Support Hearing Healthcare Patients and Provider Workforce. The item is attachment A, and the item was requested to be put on a future agenda. The recommendations are included have 4, the adoption of the International Hearing Society's International Licensing Examination and Practical Examination for Hearing Health Professionals, maintain current direct supervision rule and modify supervision requirements for trainees that fail written portion of license examination, 3, allow supervising hearing aid dispensers to supervise up to 3 trainee applicants without need to obtain a waiver from the board, and 4, allow licensure by reciprocity for audiologists, hearing aid dispensers, and speech-language pathologists. Board staff reviewed the letter and determined that the last 3 recommendations, 2 through 4, should be discussed as a separate item due to the length of the discussion about an examination. So you'll see that part of the letter is 17, agenda item 17. Part of the letter is discussed in agenda item 18. The following information in your memo is related to the first recommendation regarding national examination usage for licensure purposes. So the board is required to prepare, approve, grade, and conduct examinations of applicants for the hearing aid dispenser license that is pursuant to Business and Professions Code 2538.25A. The board may delegate the preparation and grading of an examination to an organization other than the board, so long as they comply with the established examination guidelines and the examination is approved by the board. The board, as part of this, is also required to comply with Business and Professions Code Section 139, that's provided as Attachment B, and Department of Consumer Affairs Policy, which is Attachment C. This is to develop and validate state and national examinations administered by the board or administered by contract with the board, as well as any reciprocity agreements related to waivers of examination requirements or allowance of alternative examination requirements. So this is always a great opportunity to talk about what does the board do currently. So currently the board administers a written examination and a practical examination for hearing aid dispensing. The board utilizes subject matter experts that are practicing dispensing audiologists and hearing aid dispensers to develop the questions for the written examination and utilizes the Office of Professional Examination Services to ensure content-related validity. They also make sure that we have a criterion reference passing score and that the examination is psychometrically sound. The board then contracts with PSI, which is a computer-based testing agency, and they administer our written examination, and it includes knowledge and jurisprudence examination. So when I say jurisprudence, I also mean requirements per the song Beverly, requirements for warranty and everything. So this is much different than the handwritten examination that used to be administered by the state prior to 2000. So again, we are a computerized base. We use subject matter experts. We also have, again, the 2020 hearing aid dispensing occupational analysis. The examination was reviewed after that to make sure it is up to date and current. Examination items were rewritten in order to ensure that we are up to date with the current standards of the hearing aid dispensing profession. And then every year we rewrite enough questions and items so that they all have content related validity and they're psychometrically sound. So annually we look at the written. So the board also utilizes subject matter experts that are practicing dispensing audiologists and hearing aid dispensers to develop the questions for the practical examination. And we utilize OPES services to ensure content related validity, criterion reference passing score, and that the examination is psychometrically sound. The practical examination is a practical skills examination, and it's administered by the board here at our Sacramento office with the help of subject matter experts and OPES. Subject matter experts are in the rooms when the candidates demonstrate their skills. They check off whether or not applicants have demonstrated the skills or have violated safety-related issues and been stopped. OPES, the Office of Professional Examination Services, does all of the scoring. So again, we keep things separated and ensure that everything is done properly. The practical examination has continuously been redesigned to enhance consistency and objectivity in the examination process. In 2017, the board redesigned the practical exam to streamline the examination process and eliminate information already tested in the written. Most recently, in 2020, the board, through OPES, completed the June 2020 occupational analysis of hearing aid dispenser profession, attachment D, including validation of examination content and redesign of the written and practical examination outlines. Those are attachments E and F, and examination-related materials. Since then, the board continued to discuss redesigning the practical examination and approved revisions to the proposed text on December 1st, 2023. That includes the exception for the, I believe, attachment G is the dispensing audiology part. And let's see, those changes will update outdated information and remove restrictive timelines regarding the application process and the requirement for dispensing audiologists to complete the practical exam. I can say the words. Both board examinations undergo continuous and rigorous analysis and review to ensure they are psychometrically sound, job-related, legally defensible, and uphold standards for educational and psychological testing. The board ensures all this as we work with the Office of Professional Examination Services. At this point, I would like to go ahead and ask the moderator to promote Amy Welch-Gandy from the Office of Professional Examination Services so that she can present her PowerPoint, which I believe is already uploaded, that covers how national examinations are reviewed.
This is the moderator. We have Amy. You should be able to unmute at will.
Great. Thank you so much.
And I'm in control of the project right now. If you want me to hand it over to you, I can do that.
I can just, do you mind if I just ask you to forward the slides?
That works well.
Okay, great. Well, good morning. Again, I'm Amy Welch-Gandy from the Office of Professional Examination Services, and I'm here to give you an overview of the National Examination Review process. So next slide, please. In this presentation, I will give you an overview of OPES, our office, and briefly discuss licensure examinations, then outline the steps involved in reviewing national examinations, and then after that, I will answer questions that you may have. OPES currently works with 24 of DCA's boards and bureaus and committees through interagency contracts. We develop California-specific examinations, and we also evaluate national examinations used for licensure in California. We also provide consulting to all DCA programs on examination-related issues or questions they may have. This service is provided through pro rata funds. OPES has a staff of 10 test specialists who are educated and trained in licensure examination development and validation. We make our recommendations based on law, DCA policies, professional guidelines, and technical standards. For your board, as Sharice mentioned, we provide examination development services for the hearing aid dispensers written and practical examination and perform national reviews of the speech language pathologist or pathology praxis and the audiology praxis. Next slide, please. Business and Professions Code Section 139 was created in 1999 and applies to all DCA boards and bureaus. Business and Professions Code Section 139 was developed to help ensure that all licensure examinations used by DCA are psychometrically sound, job-related, and legally defensible. They must be based on a current occupational analysis, and they must meet technical standards for validity. Section 139 requires that boards submit to DCA an annual report indicating the date of their most recent occupational analysis and other information. OPES then compiles that information for DCA and submits it to the legislature. Business and Professions Code Section 139 also mandates that all national examinations be reviewed in accordance with policy guidelines set by OPES and DCA. OPES has developed policy guidelines to support boards and bureaus in implementing the Business and Professions Code Section 139 mandate. The overarching policy is the Licensure Examination Validation Policy for DCA. This policy guides examination development and is updated as industry standards evolve. OPES has also developed supporting policies and department memorandums that provide a structure for the examination development and evaluation work that we do. The policies specify that standards for education and psychological testing are the technical standards to be followed when evaluating licensure examination programs. We refer to them as the standards, and these standards are universally accepted by testing professionals. Taking a look at the big picture, the purpose of licensure examinations and the primary mission of DCA is to protect the public. Licensure examinations help identify those candidates who can practice safely and competently from those who cannot. When developing licensure examinations, it is essential to strike a careful balance on safeguarding consumers and ensuring licensees meet minimal standards of competence. On the other hand, they must avoid creating unnecessary barriers to entering the profession. The occupational analysis plays a vital role in this process. An OA is a study of a profession to identify critical tasks and knowledge necessary for competent practice. The OA ensures that the examination is job-related and legally defensible. Subject matter experts, or SMEs, participate in every phase of the OA and examination development. SMEs are licensed professionals who are actively participating and in good standing with the board. Both new and experienced licensees participate as SMEs, and their insights help ensure that the examination reflects current practice. Now let's talk about national examinations. Business and Professions Code Section 139 requires that all national examinations be reviewed in accordance with OPES validation policy. OPES's licensure examination validation policy states that all licensure examinations considered for use in California professions regulated by DCA should be validated according to accepted technical and professional standards. California practice must be appropriately represented in an occupational analysis on a national level in order for the results to be valid for examinations used in California. The suitability of examination content for California practice must be determined by a review of the OA, including the demographics of the practitioners. These are the three parts of the national review. First, we conduct a psychometric evaluation. Second, we conduct a workshop with SMEs to compare the national OA to the results of the California OA, and we call this a linkage study. Finally, we identify the extent to which the national exam and the California specific exam together assess all of the information that California's speech language pathologists and audiologists would need to know to practice safely and competently. As part of the psychometric evaluation, we review the following areas. We review the national exam's occupational analysis methodology, their examination development procedures, how their passing score is set, how their examinations are scored, what is their passing rate. We also look at their test administration security procedures, what information they provide to candidates, and how they handle ADA accommodations. National examinations, by definition, test aspects of practice that apply to all states. If there are areas of practice that vary across states, these will not be covered. Many occupations have California-specific aspects of practice, most commonly laws and ethics. These will not be covered by a national examination. For a licensure examination, the goal is to measure the full scope of practice in California. This is why we need to complete the California OA first. Then we use those results of the California OA to determine if there are specific California-specific areas of practice that are not assessed by the national examination. If the national examination assesses most California practice, as shown in the first diagram, then we would recommend a law examination or law and ethics examination. If the national examination assesses a portion of California practice, then we would recommend a California-specific or supplemental examination. If the national examination assesses a very small portion of California practice, then we would recommend a California examination. So thank you for your attention. I'd be happy to answer questions.
Thank you, Amy.
I have a question. This is Karen. Is there a cost that comes with it where SLIPA, our department, would pay OPES for the work that you guys do? And if so, do you have on the top of your head know how much that is?
I can take over, or Amy, you can say it either way.
Sure.
Okay. So the board can choose to explore the option of looking at the national examination for hearing aid dispensing for the written or practical and delegate an organization to conduct this. But it requires that we would have to use an organization like OPES and follow Section 139 and OPES policies. One of the ways to do so would be to contract with OPES. There we had Amy mock up what it would cost to do a linkage study of an examination, presuming the board would like to move and that you want to accrue the cost. That examination of a linkage study would be approximately $31,036. It's attachment J. It's just a mocked up contract, similar to what we do for our linkage study for the praxis. So that is available to the board. So that's something we can look at. Again, I wanted Amy to tell everyone what currently would be required and what laws and policies have to be followed in the state of California to ensure that we also point out that to the extent that any examination review would find that, yeah, you can use the national examination. However, you also need a jurisprudence examination because there's enough that's California specific that you could end up with a national examination and still a state of California jurisprudence or laws examination. And that could end up being 3 examinations instead of 2 examinations, which you currently have, which have kind of incorporated everything into the 2. So those are the caveats I would give. Again, currently the board already does all of these reviews with its current 2 examinations, including using subject matter experts and psychometrically sound practices. We already look at these things for ours. If we were to take on a national examination, we would have to look at it. The other thing I would point out is that we want to look at what other state boards are doing. So we've created a spreadsheet for you in attachment K. It's the last attachment. It shows what other boards are doing. So acupuncture runs its own board examination with PSI, so it's a knowledge base and it's a computer scored. The chiropractic examiners they adopted the national examination, but because it doesn't cover everything for California, they have to have a board specific examination in law and ethics. Again, the state board runs that and they do administer it through PSI. We put this all together so that you can see in many of the categories, if there is a national examination, unless the national examination covers everything or enough of the California specific requirements, then you're going to see a national exam and a board examination administered by PSI. A national exam, board administered PSI. Oftentimes that's going to be laws and ethics. You see that with physical therapy, vocational nursing, let's see, Board of Behavioral Sciences. Trying to go down the list again. Let's see, Board of Optometry, Board of Pharmacy, Board of Psychology, and Veterinary Medicine. So quite a few of the other professions have enough state level requirements and laws and regulations that need to be covered in a state specific jurisprudence or law and ethics, whichever one it is, examination. There are some that are only the national examination. Many of these national examinations are accredited examinations, and some of those, similar to our speech and audiology, are, again, multiple occupational analyses. We go, again, OPES goes in for us. They take a look at the speech language pathology praxis and the audiology praxis. They go ahead and do that after our occupational analysis. They go and verify that the national exam still covers a sufficient amount of California specific requirements so that they don't need one. If at any time in the future it doesn't, that would become a question for the speech language pathology and audiology examinations as well. So if there was ever significant changes and not enough of the California content was covered in the praxis examinations, audiologists and speech language pathologists could potentially also have a law and ethics exam as well. Currently, that is not the case. Occupational analysis have said they are fine. This would be starting from scratch, so we would be looking at the national examination and making that determination. I provide you all of this to say, what would the board have to do if the board wanted to look at this opportunity, which the letter has requested that we discuss and look at. And it is provided for your discussion.
All right, thank you. Opening up for board discussion at this time.
So who would administer this test then, if we were to say, make the decision to adopt the national
If you
exam?
wanted to adopt the national exam, you can't just adopt it right off the bat. We would have to do the Office of Professional Examination study, and then it would have to verify there's not enough California specific content that's being left out of the national exam in order for us not to have to create a separate exam.
Right, understanding that, assuming that were the case, who administers it? Do we still administer the test? Is it now taken over by ILE? They're administering the test.
It looks as though ILE, and I could be wrong, so when we go to public comment, those that are here from IHS, as it looks like there's a few in the public comment pool online, it looks like the written portion is administered by them, but in my reading, it looked like the practical may still be administered by states, but under their, essentially, the state has to operate their exam, and there are far fewer states that have a practical exam administered under ILE versus those that have adopted the written.
Right.
So they also have more states have adopted the written than the practical for the national exam.
I mean, I guess the question is, what are we achieving by changing? Because we have a system, we have a very thorough system. You know, we know that the test in and of itself and the capacity to examine what we want it to be examining is there. So the proposed change accomplishes what goal? So I guess that's my question. I think, you know, our written exam is very accessible. That's not in terms of like waiting around to take it. You know, it's offered at testing centers repeatedly. That doesn't seem to be a barrier to gaining licensure. The practical exam has always been our challenge in terms of being able to get enough people through that want to take it, you know, each time that it's offered. And I guess if that particular barrier to licensure was being addressed in some way, you know, that would be fixed, maybe this would be something worth considering. But short of that, I'm not quite sure why we would consider the change.
Well, I think one of the potential end games is reciprocity,
Okay.
right? That's as I see it looking forward. Because if we were to say, for instance, adopt, then there's no barrier to reciprocity.
All right.
Because if they're taking the test in Illinois and we're doing the same test in California, then we should allow that person to come into the state without having to retest. So I can see that as,
But that's not what
one,
we're saying.
I mean, as I'm looking at it, that's what I see as what may be looked at as the end game to this. I have less of an issue with the written exam than I do the practical exam. There's only so many questions you can ask about, you know, hearing dispensing, you know, tests and all. There's only so many questions you have there, and so I think if we would certainly we would need it to be, you know, evaluated, but odds are those are probably relatively similar. I would be curious how the questions are presented, because I'm not a fan of questions being asked in the negative, right? And I know that's an issue, but I don't have as much issue with that because I think those are going to be, if we look at it, the most similar. My concern is the practical exam and what their standards are for the practical exam, pass, fail, and what they're teaching as this is the basic standard that you need to go with, and how different that is from what we're doing. That's my bigger concern. I'm not as much a fan of that.
I think the argument for reciprocity fails when they're going to have to take another exam anyway to come to California for the laws of California.
Well, if that were to come
skills
out,
test is
yeah.
one thing, the written skills test is going to be one thing, but our laws, they're going to have to take another test. So now we're going to, instead of taking 2 tests, you got to take 3 tests to come to California. You're going to have to still take that test.
Assuming that they find that there's not enough California that they would have to add a 3rd test. That's something that hasn't been necessarily
determined,
right? So that's all a part of the decision process. Do we adopt or don't we adopt?
But it's a
if we have to add a
costly question to ask.
Yeah.
Question.
So,
I have a question. It's an international hearing licensing exam. So does that mean that this is like a worldwide exam? So somebody from China takes this exam, and if we were to adopt this, then they can use it here?
It's the United States and Canada.
Okay. Okay.
That's where the international comes in, Canadian.
Got it. And then, okay. All right.
But I have another question then. If Todd, what you were saying about how the written was different than the practical, why are 44 states using the written and only 14 states using the practical? There's obviously some huge differences in different states.
That's why I bring it up. That's exactly why I bring it up, because clearly there are differences.
Somewhere, otherwise they would be pretty closer to being equitable.
And that's why it kind of stands to reason why, you know, maybe one without the other. I mean, clearly there's not as much different in the written, because it's kind of hard to have that much difference in a written. But from a practical standpoint, yes, obviously it can be quite different. What are your standards for failure? What are your standards for doing a test? You know, how often do you recheck? I mean, there's a lot of these little things, and I've seen a little bit of it because the company I work for, full disclosure, when they train their trainees, they train it to the national, because they're a national company and they've got people in states that use that test. So, you know, seeing some of the differences between the two. Potential. I mean, I am certainly open to looking at it. I don't want to necessarily just say no, you know, not at all, not unless we've done some sort of an evaluation. But I am very hesitant to, especially given the amount of time and energy and effort we put into the practical exam, and the fact that it's constantly being looked at and improved upon, the fact that the written test is also, you know, looked at and improved upon. You know, I don't think we're short anything here for where we are at now currently.
And it's back to Amy's things. What problem are we solving?
Right.
That
Right.
seem to be a problem.
And I think long before we're ready to say, oh yeah, let's go ahead and fork out 31 grand, you know, to OPES to do this analysis, we would have to have a much more thorough understanding of the content in these exams, the expected execution of how that, who's doing the practical, is it the state? So as the state, are we still just doing the same thing we do now, just with a different content,
test. Right.
Correct? And if that's the case, it absolutely doesn't help us in terms of our practical.
Because then we have to retrain the examiners to the new test.
Correct. And then I, you know, also would question, I know the ILE is operated by IHS, correct?
My understanding.
And so then are we getting into a similar scenario where, oh, I passed a test, but now I have to pay, you know, annual fees in order to keep some sort of certificate showing that I've passed this test current, you know, that we've gotten into in other situations with other organizations' tests. You know, and we're just finally divesting ourselves of, you know, having to pay a recurring membership fee in order to keep, you know, you pass the test, but you have to keep paying this annual fee to use the fact that you passed the test, which is also something that, you know, in audiology and speech language pathology is a current huge battle to divest ourselves of that situation. So we wouldn't want to get into a similar scenario.
So that's kind of conflating what they do for a national test versus a state test. And of course, again, I don't make any assumptions, right? But are those two separate entities, right? In which case, if I pass the California test, I have my California license, and I'm just paying California, as opposed to now I want to make the decision to take the national test so I can be, you know, board certified hearing instrument specialist and do the national test and pay a separate fee for that to have basically two.
But board certification is separate from this. This ILE practical and written is totally different.
Well, and that's why I'm saying you're talking about two, so I don't see where we would, if we took the test statewide, we'd have to then pay two premiums, if you will, because it's just California. I only see the second premium or the second fee coming into it. I wanted to take that second test. But right now we don't know, right? Because it's all just sort of in the beginning stages. I wouldn't anticipate that being a thing, but you know,
I mean, yeah,
who knows?
it's a thing in our other professions, unfortunately. So
Big thing.
yeah.
$400.
You know.
Yeah, my biggest concern is the exorbitant costs of changing.
And whether it solves any actual
Okay.
problems or barriers to licensure.
Right.
And we are the fourth largest economy in the world. So comparing ourselves to other states isn't always equivalent.
In terms of size, you
In
mean
terms of size, population,
requirements.
our laws are stricter. We have a whole different setup. So those tests and those testing us on those requirements is important.
And that is where I wanted to show you what other boards have, because oftentimes, yes, they can use the national, but then they have to have a state-specific law and ethics, law and jurisprudence. It adds another exam.
Now, it's a fair point on reciprocity. I mean, I think that's something we continue to struggle with, for all audiology, speech language pathology, and dispensing. And it's obviously something the board has discussed, quite a few times, and are hopeful that we can, somehow find a path for that, because that's that's a valid barrier, right? So.
And that would basically eliminate a big part of that barrier.
Partially, maybe.
Potentially.
Right, exactly. But as I say, I'm just trying to kind of extrapolate what the actual end game is.
The goal.
Yeah, what's the underlying benefit by being able to take that argument kind of off the table? Theoretically.
With regard to the 31,000 that was mentioned regarding the cost to do the validation study, would that potentially be passed on to the licensees as a increase in fees to offset that cost? Or how would that?
Request the contract and fit it into our budget for any year that we're doing it. So currently, right now, we're fitting in a linkage study for the speech language pathology profession since we completed the occupational analyses. So currently, we're already spending another linkage study of similar costs. So again, we would have to fit it into our budget. The board has to pay that cost. It has to come out of our budget. So we would have to request in the year prior that, hey, we need to include this cost as directed by the board in our budget. Currently, we spend about, I think it's 28 to 30,000 every year working on the written examination to keep it current and valid and psychometrically sound. So that would make that budget year go up to 60 grand. Right now, we're already looking at adding in an occupational analysis for audiology next, which would take up most of that budget in the next 2 fiscal years. Again, I'm trying to spread them across so that we can get budget sound wise contracting done. So this would need to be taken into consideration. It will come from our fund, and it will just be charged to the fund. So again, it's not immediately going to impact how much we need to charge licensees, but it's a fee we would have to pay, and it would have to come from our fund. And because we run tightly after the governor's budget reductions in the past couple years, we would need to pre-plan. So we would need to make sure we ask for this money the prior fiscal year, get it approved, make sure it's in the budget, because we're not going to have any money to just decide to do it on a whim.
Yeah, thank you for that. Thank you.
Now, one of the other questions might be, this is an item for discussion, and if the board would like it, we could ask those from IHS ILE to go ahead and come and give us a presentation on the information. That's always another option. This information was to give everybody a background on what's currently required, what are the legal requirements, what do we currently do with our examination, and what are potential outcomes, i.e. a third examination, when we go to look at this. And this can then be brought up if a board member would like to request that it be put on a future agenda. It could be put on a future agenda at that time. But here are all the considerations for the board members to think about prior to making that action, because there's quite a few. Did we have, correct my memory. I feel like recently we asked to circle back and have an update from the reciprocity people, but maybe it was that they don't have too many people participating yet. That coalition that came and presented previously. The compact is currently active. It is not issuing privileges. So they have not actually started issuing any privileges. Okay. I provide you this also so all of your professions can look at it. In the policy by DCA on page 7 of that policy, any reciprocity agreement has to also be reviewed by OPES. So we would have to make sure the linkage to any reciprocity is also verified, that we're meeting the same or similar requirements, and that any examination that's being waived is being supplemented by an equivalent examination. Now, for you guys in audiology and speech language pathology, you're already taking a national examination that has been validated to be content specific enough that it covers California. But again, we would need to make sure we check all those things. We do the same study and call it a day. So, but that's where all of these kind of agreements need a review process. And so it's not just a make a decision, call it a day tomorrow. And currently we do not have all the information from the compact for that side. Now the compact has other things about privileges and people coming in and then discipline. That's different as well.
So the OPS survey, the $31,000.
The linkage study. Yeah.
Linkage study. That's just basically looking kind of a little bit broader view. Are their tests mirroring our tests? Are they asking what we're asking? What are the differences?
And is there enough content, California specific? So
Content.
they'll take.
I understand that.
Yeah, they'll take your 2020 hearing aid dispensing. It's in your attachments. Sorry, that's why the attachments are so big. The occupational analysis done in June of 2020 for hearing aid dispensing profession. It would take that occupational analysis and do the study compared to the national exam. If we end up getting to another hearing aid dispensing occupational analysis before doing said review, we would do that newest one, whichever it is.
But they're not necessarily getting, or are they getting into more granular as to, in regards to the practical exam? What's actually being covered in the practical exam specifically? What's considered a pass? What's considered a fail? What's a stoppage? I mean, actually getting into the granular of how the practical exam works in relation to what we have as pass, fail, stoppage, to see what the similarity, or even the how it works, how you're going to present a tone and things like that. I mean, I would want to get down to the actual granular of what's in it as it compares to what's in ours. Are they more strict than we are in certain areas? Are they less strict than we are in certain areas? Because that could be a red flag one way or the other, that we want to, do we want to adopt it because for whatever reason, the way that they're scoring it is completely off from how we're scoring it. What they're asking the person to show for minimum competency, is that the same thing we're asking to show for minimum competency, or their idea of minimum competency way out of whack from what we think of as minimum competency? Those kinds of things, as we're looking at, do we adopt it or not adopt it? Those are the kind of questions that I think need to be answered.
It's you're talking about not just content, you're talking about weighting, essentially.
Both,
Like how
yes.
we weigh,
Both, actually,
weights.
both.
That's right.
Absolutely, yes.
I would defer to Amy Welch-Ganby from the Office of Professional Examination Services if you want to unmute, because the level of detail you're asking about, I don't typically get involved in. I leave it to the psychometrically sound experts.
I don't know how they can get into that because they don't know what to do.
We would look at the examination development procedures, and I think in one of the attachments, I don't have it open, there is a list of what we request from the national program.
Yeah.
We look at how they set their passing score, their process for developing the exam. We look at how it is scored and how they determine their passing score. So we would compare the two practical exams with subject matter experts to see if the subject matter experts thought they were equivalent.
And just so board members are aware, that material is attachment I and J that are after the national review. Or sorry, attachment H and I.
Okay. Well, in my mind, that's still kind of more of a broad view than getting a little more granular. But
I guess the question today, really in front of us right now, as Sharice maybe summarized a little bit ago, is does this bear further discussion? And if it bears further discussion, ought we to agendize it for a future board item and invite the people that operate the ILE to come and give us more information about those exams and answer other questions that we may have? Or do we want to just move on and not consider talking about this further, I guess?
Yes.
Guess what?
I agree.
You agree with what?
Everything we said. I knew I was just not sure. I'm not sure I'm mistake.
Do you want to have it agendized as a
Well,
future item?
I think we need to get,
discuss it
yeah,
further?
I think we need to have, more, whether or not we just, the person who happens to be on the line now, to get into that, or we just have a whole other section dealing with that. But we need more information, certainly, I think.
Okay, so do we need to make a motion for an agendized item, or we can just ask?
You can ask. Any board member can bring any future agenda item and save it in the future agenda items at the end of the board meeting, and also bring it to the board chair. Either option works. You can also direct staff to go and research additional information to bring back to the board, including potentially a presentation by IHS if that is what's.
That's what I vote for. What you just said. I think it would be good for the office staff to continue to gather information and then request a presentation so we can have additional information before we make any other decisions.
Yes, I agree. I agree.
Okay.
What do the other board members think?
I agree. I actually have some questions that I'll write down and send it so you guys can do further research.
Sounds great. If everybody wants to send their question, board staff can include it in the next time. And if one of the board members would like to make the future agenda request in agenda item 20, that includes a presentation by IHS, we can do that. Are there any other questions about the policies or the legal framework that is required? Or anything we want to ask of Opez and Amy Welch-Gandy while we have her?
I guess the last one that I would have was then if the third test is required, what would be the costs of developing that third test?
I would suggest it's probably the same cost that I have to pay every year to create the written exam.
So another 30,000.
Potentially every year $30,000 where I continuously rewrite that California specific examination. And again, with subject matter experts, that's psychometrically sound and so on and so forth. And again, administered in a computer-based examination with PSI.
So any thoughts of this whole process saving us money? It's not the factors, this is all costing us.
We would have to do all the studies before figuring that out, but it could potentially cost us the same. I would just be writing a separate examination that would be different.
Other than the costs of the analysis,
yes.
which would be.
Well, that sounds like a lot.
That was actually my question.
That's a lot.
Would it cost? Would this be potentially be saving us money or not? Separate of the $30,000 cost.
I think we would need to also have IHS presentation because it looks like the state would have to still administer the practical exam. It would just be administering their practical exam instead of our own practical exam. So the board wouldn't save any money on the practical exam is my guess, potentially. But the savings on a written exam could be essentially moot if we have to have a California jurisprudence or laws exam that's specific to California. Because currently we include law and ethics, well, not ethics, but law questions and warranty questions into our written exam that's already administered by the board through contract.
Which I can't imagine that 44 other states have California-based laws in the exam for.
No.
So that's something for the board members to consider.
Yeah, the return on the investment.
But I want you to have the information, and I think it's also a great opportunity, again, to share with the board all the work that the board already does, even though it looks in the background. we are here doing all this work. It does cost us a good penny. And that's why we, manage our budget so prudently. But this is part of sharing with the board. What are we currently doing? What would we have to do if we wanted to change? And we need to know more information in order to determine that return on investment question.
Yeah.
Get cost analysis on that one?
Oh, Francis?
Are we able to get a cost analysis if we do that?
I think you would have to do the linkage study. Amy, correct me if I'm wrong, that we would have to do the study first to determine whether or not a California-based specific law exam would be required. And if so, then to set up an estimate of what it would cost to administer it every year and to rewrite questions on an ongoing contract like we currently have for our written examination.
Yes, we could give you ideas of what other law exams cost. If we were to guess, I don't know if that would be helpful or not.
It could be helpful if when we bring this back to the board to know what other California boards annually have to spend on their law and ethics exams or their law and jurisprudence exams.
Yeah, I can provide that to you.
Thank you, Amy.
I have one quick question just on that. But in attachment G, the general application requirements and hearing aid dispensers fits in the exam requirements. In C, the practical exam shall cover the procedures and use of instruments and equipment commonly employed.
I'm trying to get there.
Yep, no worries.
I'm not.
They're currently practicing. Go through
Oh, let me.
Hey, Donna.
Okay,
It's
go ahead.
page 7 of G, I believe.
Page 3 of 7 of the regulations from the December 1, 2023 proposed text regarding the hearing aid dispenser general application requirements and dispensing audiology.
Okay, so this is just a recap of what we discussed.
Yes, this is just the
Okay.
regulations the board has already discussed.
All right, because I'm seeing something in there about the test should include. I mentioned SRT, so I was just wondering where that came from. But that's just a rehash of 23. That's
Yep.
fine. That's great. Thank you.
Okay.
Okay, just a comment. We were wondering if that would be a deterrent for outside professionals to come into California.
If what would be a deterrent?
The extra requirements would be a deterrent for outside professionals to come into California.
I think some would say that that's currently already their deterrent is that they have to come to California and pass our state specific exam.
I think that's the reason for the letter.
Yeah.
Exactly.
But they still come.
And currently, I would say that again, while we don't have reciprocity, speech and audiology do have the certification is a help to get you licensed. Again, they all require the same exam we require, so that's where it's very similar. But it's also done statutorily, so it's not exactly a reciprocity. But you have to have done the exam and some other things, and you have to keep your certification current. And I don't think we've ever had anyone ask to propose anything about the hearing instrument special certification thing. So we don't have that in statute like we do for speech and audiology. But again, you would have to review it because anytime we're going to say you're excused from an exam, we'd have to make sure whatever exam they're taking, it's equivalent. And if not, what are the requirements still there?
Okay. Are we ready for public comment?
I think so.
Okay. I'll check in with the on-site locations. There are no members of the public present with us at this time.
There are no members of the public with me at the City of Industry location.
And there are no members of the public at the Sacramento location.
All right, thank you. I'd like to ask the moderator to open public comment on WebEx.
We are open for public comment on the OPES presentation. If you'd like to make a comment, please raise a hand by tapping that hand button at the bottom of the screen. Dial-in users dial *3 to raise your hand, and we will call on people in the order we have requests. And our first request is coming from IHS Sierra Sharp. Hold on just a moment, please. We're sending you a request to unmute your microphone. And we might have lost them. Let's
Sorry
go
about
to...
that. Can you hear me?
Yes, go ahead, please.
Okay, thank you so much. So my name is Sierra Sharp. I'm the Director of Professional Development at the International Hearing Society. It was great to hear all of your discussion about this very important topic today, so thank you for considering it. I would just start by saying I would be, more than happy to give a presentation at a future board meeting if that's something that the board would desire. That's something that we've done for other states on the topics of both the ILE, the written exam, and the practical exam. I heard a few questions come up from board members that I would just go ahead and address. Number one is annual fees once somebody passes the exam. That is not a thing. So any state that chooses to adopt either the ILE or the practical exam, it basically just takes the place of their exam. So your California exam would be the ILE. They pass it and they're done. They're, of course, paying their licensing fees to California every year in accordance with what the board has established, but there would be no ongoing fees to IHS. As a professional association, we do have members, but that is something that's totally separate from passing the ILE and the practical exam. A couple of other items that were brought up, just confirming that for the ILE, IHS does administer that exam. We handle it completely. The state decides who's eligible for the exam. So you would tell us, as people meet your requirements, you have total control over who's taking the exam. And then we collect the payment, we administer the exam, we provide a score report. And then, of course, we're handling all of that psychometric work. Hopefully it goes without saying, we would be, more than happy to fully participate in a linkage study, and would certainly support the board in carrying out that operation if the board so chooses. The practical exam is currently administered by the individual states that have adopted it, as you mentioned. We are exploring other options for that because we know it is an in-demand service. State boards don't particularly like administering their practical exams generally, so that's something that we're looking at, but we don't have any anything definitive to share on that at this time. Changing to using the IHS exams, as was mentioned by a board member, often can ease the burden of reciprocity for individuals, prospective licensees who are coming in from other states. In some states, there is also reduced
30 seconds.
less. Thank you, because of IHS taking on the psychometrics and all of that. Obviously, you have the potential consideration of would you need to have the supplementary laws and rules or jurisprudence exam, and we'd be more than happy to work with you on determining all of that. The exam is used in the US and Canada, and one board member specifically addressed how questions are presented. We do not present questions in the negative. They are all dichotomous scoring, so either right
Time.
or...
Thank you. Next, we're going to hear from Thomas Tedeschi. Hold on just a moment, please. We're going to send you a request to unmute your microphone. If you're on a mobile device, Thomas, you may need to hit the ... button in order to cycle through the pages. I'm going to go ahead and send you a second. Welcome. Go ahead, please.
I'd like to thank the board, first of all, for considering this item topic. And just in short brief to say, I would like to just suggest that the board would consider this as an agenda item for the future. It would help with reciprocity. but also the ILE examination is updated very much so annually. Plus, there's a great deal of linkage between the ILE exam and online learning materials for the potential licensee. And this would help facilitate individuals coming into the profession to learn more and more in depth before they take the exam. So this is a very good opportunity. Also, in a number of states, as you pointed out, that there are an additional examination, which would be for licensure, which would be for laws and ethics, and they do that as a separate. And some states require that on an annual basis or every couple years for the laws and ethics portion, but that would be up to the state of California there. But I would strongly like to suggest that this be a future agenda item that could be then have the ILE individuals from IHS present on the cost savings that it could provide, plus the opportunities that it could provide for reciprocity and also for the state of California. Thank you.
Thank you. Next, we're going to hear from Joe Bartlett. Hold on just a moment, please. We're going to send you a request to unmute your microphone.
Okay, can you hear me there?
Yes, go ahead, please.
Very good. I also would like to thank the board for taking up this topic. I know it is something that has been addressed, and HHP's kind of mentioned it a little bit in the past as what happens next. And I think one thing to keep in mind is not even just reciprocity, but the upcoming training regulations require some level of trainers being trained. And this is all encompassing in this ILE program and the distance learning program is actually having a platform to train people that now need to train. Because as currently it's written, you want people to train the trainees in California with no real background except for they just have a license. So it's one of those more global things where we have a better standard of what a trainee is supposed to know and a trainer is supposed to know. So I would definitely like you to consider that. And also when it comes to the laws and the further testing, I've followed this stuff a lot over the years, and I do question whether or not something along the lines of the advertising laws and things that we have in California, if it could not be an attesting each year with your licensing renewal, something to say I attest to follow these laws, and then having maybe something further test along those times, like Tom said, if it's just a matter of every couple of years going through and attesting that you will follow those laws and that being held to those laws versus it being a study and a major undertaking. But I do would love to see this on a future agenda item with a full presentation. So please, if you could, that'd be great to have that on there. Thank you.
Thank you. And that was our last request for public comment on this topic.
All right. Thank you. We will close on this agenda item number 17 unless Ms. Burns, there's another advisement otherwise.
Nope, we have direction to staff, and then board members can make sure they ask in 20, the future agenda item, and we'll go ahead and go from there.
All right, okay, thank you. Thank you for the advisement. At this time, we will go ahead and take a lunch break, 45 minutes. So that puts us at, what, 1:20? So we'll go ahead and reconvene at 1:20 following a lunch break. Thank you. Okay, good afternoon, everyone. We are starting our meeting again for the Speech Language Pathology and Audiology and Hearing Aid Dispensers Board. As our recording started.
This is the moderator. We are recording.
Okay, thank you. We will reconvene with agenda item number 18, discussion on hearing healthcare provider letter regarding workforce shortages and recommendations to address those shortages through licensure, reciprocity, and changes to regulations regarding hearing aid trainee as stated in Title 16, CCR sections 1399.114, 1399.116, 1399.117, 1399.118, and 1399.119. I'd like to ask Ms. Burns to present information on this agenda item.
Hi, Board Chair. Apologies. We just want to actually double check in each location that every member is back. So can we do a?
Thank you. Thank you for the reminder. Here at the Glendora location, we do not have any members of the public, and all three of us are here. Myself, Dr. Chambers, and Francis David. Here. Okay. At the Sacramento location, do we have Dr. Amy White present?
Yes, I am here.
Mr. Todd Borges?
Here.
Dr. Charles Sanders?
Here.
Thank you. And at the location where Ms. Karen Chang is, confirming that you are present?
I am present.
Okay. And do you have any members of the public with you at any of the locations?
I'm at the City of Industry location, and I have no members of the public with me.
Sacramento?
There are no members of the public in Sacramento location.
All right. Thank you. And we'll go ahead and resume with agenda item number 18 as previously announced.
So again, similar intro. This is the letter that was brought to the board in order for us to discuss the 4 points of interest. This 18 is about maintaining current direct supervision rule and modified supervision requirements for trainees that fail written portion of license examination. 3 allows supervising hearing aid dispensers to supervise up to 3 trainee applicants without need to obtain a waiver from the board. And 4 allow licensure by reciprocity for audiologists, hearing aid dispensers, and SLPs. So this is the second agenda item to address the letter. And then I'll go ahead and cover each item as well as the attachments provided, some of which are duplicative, so you didn't have to flip through as much of the binder, just so you're aware. So number 2, the maintain current direct supervision rule and modify supervision requirements for trainees that fail written portions of the license exam. The board's been discussing the regulations regarding trainee supervision since 2017. The board took a look at these regulations in 2017, 2018, and then also took a look at them in August of 2022, October of 2022, and February of 2023. And then the board approved the language at the August 18th, 2023 board meeting. And so a hearing aid dispenser trainee license is a license meant to help individuals with no formal hearing health education or experience to gain the knowledge and experience necessary to become permanent hearing aid dispensers. And it's not a license to function as support personnel for a hearing aid dispenser. So unlike speech and audiology, there is not an aid position or an assistant position within the hearing aid dispensing structure. So the hearing aid dispensers, part of the letter, it talks about shortages and increased demand for hearing healthcare services, including hearing healthcare provided by hearing aid dispensers. But we don't have any of that workforce shortage data. I knew I was going to botch how to say that one. And either California or nationally. So we might want to ask for that. Oftentimes when the legislature asks us what workforce shortage we're speaking of, we don't always have data to provide them. If we do have that data, it would be nice to have that, so just as a reference. Again, highlighting hearing aid dispensers, we don't have an aide, and I'm not completely sure why that is, but we don't have an aide or an assistant or any sort of support personnel. Currently, you just have trainees that you're training to essentially get a permanent license the same as yourself. So it's really not intended to help increase your labor workforce, as in have additional support personnel so that you can essentially meet more clients. So that's kind of a different focus. So really what the board has been focusing on since about 2017, 2018 in different meetings is on providing sufficient training and supervision so that trainees can gain the knowledge and skills to pass the examinations and enter the workforce as licensed hearing aid dispensers sooner and within the first 6 months of the hearing aid dispenser trainee license. So unlike some other licenses, this isn't a professional experience portion of the license where you go and get your education and then you come do the professional experience. This is gaining both the knowledge and the experience, but was intended, interestingly, to be a 6-month license that can be renewed twice. So it can go up to 18 months, but it actually is intended to be a 6-month license. So the hope would be is if we increase the amount of training and experience that they can accrue, and especially the amount of supervised training they're getting within that first 6 months, hopefully they could be licensed sooner and we have fewer people going to the 12 and 18-month mark. We do see quite a few going to the 12 and 18-month mark, as well as surpassing that and having to exam only and not dispense hearing aids. Because there is a gap between, if you don't pass, you can continue trying to take the exam, but you cannot dispense and be a trainee for 3 years before you can come back and try again. So part of from the regs that we've been working on is to increase that training and education and experience that they're getting on the job, because again, this isn't in a classroom. So the board, the belief is that increasing that level of supervision will ensure that trainees are being trained, observed, guided, and assisted more frequently and intensely at the beginning of their temporary license or trainee license than they currently are, which hopefully would result in more competent trainees who can pass the examinations much sooner. So the board wants to provide why we've been going in the route we've been going with the current trainee regulations, so that we can kind of understand where were we going. So the request in the letter is to move back or to keep the current regulations instead of increasing what we've been working on for years. So the other component is increased supervision levels for those that fail the examination. So part of that is the written. If they fail either, they have to move to a higher level of supervision under the current regulation. So those who fail the written examination for the first time, they've essentially failed to demonstrate that they have the minimal competency, knowledge, and skills required to provide safe and effective service to the public as an entry-level hearing aid dispenser. So accordingly, to set an accepted professional standards, we increase the level of supervision after failure in order to hopefully get them back and passing the examination sooner, so they're coming up to that minimum standard sooner. Now, the law is very specific on how long you can do it. So again, you have 6-month period, and then you can renew up to twice. I would give the caveat, you do have to take the examination by the 12-month mark, or we will not extend that trainee license to go another 6 months to the 18-month mark. And we do have people that run into this barrier quite often. So if they fail to pass that exam, they can't work, or they have to increase their supervision. If they don't get it done by the 12th month, they also have to stop there. There's a minimum of 3 years between when they can be a trainee again. The board's hope is that, again, increasing that first 90-day supervision that's in the regulation that was approved on the August 2023 meeting would help ensure that more people are passing the examination sooner, because they're getting more of that in-depth training and supervision early on. So again, that's the hope. That was the intent. Still very much up for discussion. So in that vein, that's also why the changes to the regulation also include specifying certain training requirements that the regulations want to ensure, so that there's more uniformity in how the trainees are being trained to enhance their ability to pass both examinations and enter the workforce as hearing aid dispensers more quickly. What it doesn't talk about here, and there's always the room for a discussion in a future different agenda item, is the question mark of, again, why don't you have support personnel, and whether or not that's actually also needed. So that's a whole different conversation, but I just want to throw that out there that that's not discussed here, but that's also something we haven't ever, that to my knowledge, I don't know that we've ever talked about. The third item was allowing supervising hearing aid dispensers to supervise up to 3 trainee applicants without the need to obtain a waiver. So the letter notes that the current regulations allow audiologists and, well, they mean SLPs, to supervise up to 3 temporary license holders without special approval from the board. But we would note audiologists and speech language pathologists can supervise up to 3 RPE license holders without special approval to obtain that supervision level, because those licensees, the RPEs, have completed 300 clinical clock hours of supervised clinical experience and have either completed in its entirety their master's coursework for the speech language pathology career path or are on their very last year of a doctoral program in audiology. So they come into that experience category with extensive education and a certain number of hours of supervised clinical training. This is not the same as when we get hearing aid trainees that don't have to have any formal hearing health education, no formal experience. None of that is involved in the trainee license category at the moment. So a discussion of parity amongst the professions is a little bit, you know, apples and pineapples, right? It's not exact apple to apple. So that is one of the other things that we should have to consider when we're talking about that. But again, the use of support personnel is something that might be worth addressing. If there is a workforce shortage and we can be provided with that data, and hearing aid dispensers do need aides in their offices to perform other minor functions, that could be worth discussing in the future as well. And then the board has been discussing changes to the regulations for hearing aid dispenser trainees for quite some time. So if we want to consider those again or further, or really take them up again, the board can also bring them up for review and revision. Currently, the rulemaking is on hold at the moment, but it's in the preparatory phases. So the board has approved it. Staff would be working on the internal documents in order to get to the Office of Administrative Law. That includes all of the internal levels at the Department of Consumer Affairs for approval to get to the Office of Administrative Law and notice. So that's where they're currently at. The board has already approved them. The board can always look at them again if they wish to. Either way, any sort of comments, whether it's through this mechanism or through comments on a regulation, the board would have to address at some point in time. Number 4 was about allowing licensure reciprocity for audiologists, hearing aid dispensers, and SLPs. So the board doesn't have specific reciprocity agreements with any state organization or any states. It does have some out-of-state applicant pathways for temporary licensure. Speech language pathology and audiology, they have the option for the 6-month license. If you're coming in from out of state and you want to dispense hearing aids, it is a out-of-state temporary hearing aid dispensing license that you would get for 1 year in order to pass the exams. You can also be working at that time and dispensing hearing aids. There is a certain amount of deemed equivalency when it comes to speech language pathology and audiology if they have their certification of clinical competency or board accreditation, the certification from AAA, from the American Academy of Audiology. Again, all of those things, if we're actually going to look at reciprocity, I would point us back to our attachment, which is the attachment on licensure examination validity policy from the Office of Professional Examination Services. So that's OPES policy number 22-01. And in those, all reciprocity agreements would have to have the linkage study to determine that whatever provisions we're allowing instead of the state of California's provisions, they have gone through that process to review that they are equivalent and that there's nothing California specific being missed. And if there was something California specific being missed, you would have to make that up. So again, you might need a California law and jurisprudence examination. Just to clarify that it still would have a process, you'd still have to have that national linkage study. And that's what comes with it. There are a couple ways to expedite licensure since the letter talked about that. Military spouses and domestic partners can apply for a 12-month temporary license pursuant to Business and Professions Code 115.6. They can again take those examinations along the way while they are temporarily practicing under that. And then service members and their spouses or domestic partners can also register to practice under federal professional license portability and state registration pursuant to Business and Professions Code 115.10 if they are licensed in another state and providing the same services. So these are all different ways that we allow either expedited licensure or shortened versions of licensure, none of which are actual reciprocity agreements for these things. And again, any and all reciprocity agreements, you have to follow the OPES policy and make sure you do that review. So as discussed in 17, we just need to make sure we're following any state laws and any DCA policies whenever we're looking at reciprocity agreements. Similarly, when we look at licensing compacts, that's the same kind of stuff we'd be looking at. That's not here, but again, I'm just saying in general. So anytime we're looking at that sort of, we want an alternative route than California requirements, then we have to look at these things. So if the board decides to continue the discussion at a future board meeting to further study the national examination, reciprocity agreements could become part of those studies, if that is requested at that time. But there's three different parts. So one is about the direct supervision and essentially reverting from what the board has approved in 2023 back to what's currently in law at this time. That's about the supervision, including their request that when they fail the examination, that the increase in supervision not be included. Their recommended change, let me get to their page on it,
50%.
was 50%. So they would like a step up in the percentage of supervision after the exam has shown that you don't have the minimal competency to proceed, that it only steps up supervision 50% instead of fully to 100% to get you sooner to passing the written examination.
But it's just the written exam that they're saying, not the practical.
Correct.
The practical would be 100. They're just saying the recommendation is 50% for not passing the written exam.
Yes, but again, the written exam is that you don't have the basic knowledge and understanding of the laws for basic competency.
Well,
just to point it out.
Yeah. I mean, that being said, though, I know people who fail the written exam 3 times and pass the practical first time up. So, sometimes people don't pass a written test just because they're lousy test takers. Not that they don't necessarily have the knowledge. I mean, you're going to extrapolate that based upon just the information you have in front of you. But the supervision is already, there is no indirect as it stands. So they're already going to be in the office with them, supervised directly by them, whether it's immediate or direct.
In the new regulations.
In the new regulations, right. So, I mean, to go from 20 to 50, I don't honestly think you're losing anything because the person's there already anyway and basically in the room. The only scenario that would play out is if I'm in an office and I'm running 2 exam rooms and I'm doing tests in one and the training's doing tests in the other, right? Then, then the 20 versus 50 has a big impact.
Currently, the 20 to 100.
Or 100 versus 50 has a big impact in that regard.
Does the new, not yet, the language that we already voted on, does it talk about a change in supervision related to exam failure?
It does. Let me find the page.
I don't believe it actually does because there's.
Or is it not changed? Is that why?
Well,
I don't believe there's any changes. I think
Right.
it's still the same that it goes 100.
Because we were discussing that as a possibility. So we're basically just changing the supervision from indirect and direct to direct and immediate.
And no one was
So-
envisioning reducing the amount of supervision when somebody fails the exam.
No.
No, it's on the last page, on the top of the last page. We're just using the new language, the immediate and direct, but it will remain the same, that if they failed the written and or the practical. So I think that would be the only difference, is that if they fail if they pass the written but fail the practical, they would also be subject to that requirement.
So it's reverting them back to, because right now the language that we voted on has the trainee under immediate supervision for the first 90 days and then moves to direct after that. And then what we're saying is, well, okay, if you fail the exam, then you're going to revert back to like under your first 90 days, where now you're back to immediate.
Right.
We don't have a
Yeah.
time.
Right. It's just
But
one.
it's kind of the same thing.
Right.
You need to be there every time.
Mhm.
Right.
So it's back to 100% just without calling it with percentage points.
Right. Because it's not really right, because you're going from immediate to direct. It's not that you have to be direct for X percentage and immediate percentage after the 90 days. It's just straight direct. So
Right.
in that regard, there is no, then it's just the decision actually is, do we want to change it from, if you fail the written test, the way it's written now, it would be, if you fail the written test, you stay on direct versus going to immediate. It's actually, since there's no percentages anymore.
Yeah.
So that's essentially what we're talking about.
That would be relating their request to what we're doing now.
Correct.
Yeah.
Right.
And so those would be the three considerations.
Well, Sharice, I really like your point. And I think over the years of having these discussions, that's a conflation that happens a lot, which is, well, but you're taking my trainee and making them not useful to me. And you're like, wait a minute, but they're not supposed to be useful to you. They're a trainee that you're supposed to be useful to them, not the other way around. It's a mentor-mentee relationship. It's not I'm employing someone for extra labor to get around. Yeah, they don't have the license yet, and I'm employing them as a second dispenser. And I think that's the gap. I think that's the communication gap a lot of times, talking about the trainees. And that's why this continues to come up. And I get it. I have, I've definitely heard before that, well, what's in it for me? Why would I take a trainee if there's nothing in it for me? They can't see they can't see clients. They can't, what's in it for me? And the answer is there isn't anything in it for you. I mean, there's not, and there's not supposed to be. It's just like when we take on externs or interns into our practices, and we're allowing them to get into patient care, and we have to supervise them 100%. We're right there, for those interns. It's a huge time suck. It's a lot of explaining. It slows your day down. It's a lot of time and effort and energy, and you do it because you want to give back, or you do it because you want to help this person, achieve what they're trying to achieve. You don't get anything out of it.
But it's a responsibility of the profession.
It's a professional responsibility. Yeah. So I think that's a really excellent point to say it that way. It's not, this isn't meant to be your employee that's going to make you money or make it easier. I also think it's a really excellent point that if that is how trainees are being viewed and being used, which isn't in the spirit of what's written already, that if there is a gap there in terms of assistance or some sort of an aid, yeah, that is a great point, that maybe that's the conversation that really needs to be going to, so that we stop, trying to think of trainees as these assistants to help us get other things done in the office that need to be done. And maybe we do need to open up a whole conversation about another type of help. Although I think right now, a lot of that help probably comes from like front office staff. But
right. Because they could do cleaning checks as long as they're not touching the patient. That stuff is generated by patient care coordinators, front office staff.
Mm-hmm.
I mean, to your point, right? Am I looking at the trainee as someone I am training in my vocation, or am I bringing this person on as an income generator?
Well,
Right.
future
And
income
that,
generator.
well, but no, but as with the 80-20 and the indirect and all that, that is because I'm really getting an income generator that so we can make more money, and then that justifies me taking this person on.
And that's not really what it's intended to do.
Exactly. Exactly.
Right. Yeah, I agree with you. I think that is the common perception,
Right.
and that's why I'm saying I think this communication gap and the way that you spoke is maybe a nice way to address it. That isn't the spirit of what that position is or that license category is, and it's been used that way, but that's not how it's intended to be used.
And if the board decides they need it, then we should start having those discussions at another board meeting with it agendized about what kind of support personnel hearing aid dispensers do need because of the workforce issues, because that's really the opportunity to address it. And so I think that they're slightly separate conversations, but also when you're going to talk about, we want you to scrap what you've been doing to try to improve training and supervision, because we want to revert back for workforce shortage needs. Those are two different conversations. And we should talk about workforce issues for hearing aid dispensers as well, and have the committee, the hearing aid dispensers committee, talk about what do they need in their dispensing locations, because they don't have audiology aids. And
then how is that different than what they already have?
Exactly. And is there a way to improve that? Right? I mean, so again, it might not exist right now, but maybe we need to start looking. Again, we talked, we showed you in the speech language pathology practice committee, the occupational therapist worked with the community college to do a workforce survey on something. These are things that can be done on the different professions if we need to say, hey, we see a gap here. Is there a need? And then again, the board has to look at consumer protection. So we're not going to create license types unless there's a consumer protection need, but we can always be supportive, provide technical support. If the Hearing Aid Dispensing Professional Association wants to look at, no, we do need aids, or we do need assistance, and we would like them to do this. And how can we do that in a way that protects consumers, but also advances the association? Again, the board's not in the business of advancing the profession. That's what the association is for. But to the extent that our efforts of consumer protection and public safety are interlaced together, if there's something going forward, that's where the board can be supportive and provide technical assistance.
Well, and I think, I don't remember, Todd, if you remember the last time, and maybe we,
Of course I don't.
You don't remember. I think we've danced around at times, or maybe brought up as a discussion, not anything to ever take an action on, about, do hearing aid dispensers in California want to pursue an educational pathway to create more dispensers? Should there be an associate's degree, that would allow a high school graduate or someone who started college and changed their mind about what they want to do, whatever, or knew they wanted to be a dispenser, go in, take their coursework, and then they would enter the field much like an audiologist or speech language pathologist in terms of already having some education, which would then perhaps open up opportunities for those trainees to then come in under a different, to be treated kind of more differently. Like, this is their clinical experience
Kind of
after they've done.
version of an RPE.
That's exactly right. In which case, the use in quotes, the use of them and what they can or can't do in the office would be then perhaps very different than what it is right now, because they have this different pathway. They've had the education, and I know that. I think the last time I looked in depth at this had to be at least 10 years ago, where I was trying to audit, what other states have, and there are a number of other states that do have like an associate's degree pathway, or that is the requirement for entry for a hearing aid dispenser. And, I think that maybe that's a conversation for the association, maybe to start looking at if the hope is that you can get trainees in and have it be more like an RPE and have them, be more useful, quote unquote, or be able to experience things without all this direct supervision.
Right.
I think that would be a great way to make that happen, along with various other things that have come multiple times about, wanting dispensers to do XYZ things that aren't currently allowed. So I don't know. It's just a thought. I can't remember if we've talked about it at the practice committee before.
I don't think we did talk about that at the practice committee before. Not an actual formalized 2-year type of program.
And again, as Sheree said, it's probably not the board's purview to like force, like not force, that's the wrong word, to even take that up and like push it. But the discussion, I don't know if that's something of interest.
Well, that would all start with an actual workforce study.
Yeah.
Dr. White.
Yeah.
There is actually a law that does allow the board to recommend the preparation and administration of a course of instruction before for as part of the licensure. That's Business and Profession Code 2538.17.
The board has never taken advantage of the statute and initiated such procedures, but it does have the statutory authority to do so.
What would that mean? Can you put that in, like, what can that mean? Yeah.
That if the board so directed the staff to do so, we could start opening up conversations with the community colleges, I believe is what's named in there, about educational coursework about that could be required. I believe it specifies some requirements in there, and then we would go forth in that manner.
Is that kind of how the whole SLIPA programs were, or did they exist? I mean, I have to imagine before we had SLIPAs in California, there were no such programs. And
there were not.
But that was through an association.
The association pioneered that through a bill. Of course, once you create a category of licensure, many people will pop up to be able to provide that. Because again, people were already going and getting an associate's and then going on to the bachelor's for a communication science disorder degree.
Mm-hmm.
That kind of leads into, there's already somewhat of a pipeline here because people were going that direction. And then from there, you can move along, right? So this one talks about, if the board wants to promulgate regulations and work with the community colleges to create such a requirement, it's a possibility, and then that would be part of the licensure for hearing aid dispensers.
Well, I don't think that ultimately, I think if that's kind of a non-issue, because I think if you do an actual workforce study to see what it's like out there, given the narrow scope of practice that we have as a dispenser, I don't see where that's really realistic. That you're going to inundate the market with literally dozens, theoretically, of people and nowhere to go. From the audiology side, you have multiple avenues of work or job opportunities to do different things, whether it's dispensing or clinical, cochlear, lots of different things you could do. We do one thing. We test and fit hearing aids.
Currently, you do one thing because the education and experience requirements are what they are. So there is a little bit of cart and horse or chicken and egg question. So again,
it would have to be much meatier. What we do would have to be, that scope of practice would have to be expanded to make something like that worthwhile. I believe that could be a part of that conversation as well, if we want to actually talk about expanding our scope of practice.
Well, yeah, and I think, when you look, at least when I'm looking, I'm like, well, I was on the IHS site last night trying to look up things about the ILE, and it was talking about adding tinnitus into your practice as a hearing aid dispenser. And, we've had that conversation multiple times, how here in California, that's not a thing. However, I'm sure, not sure. I imagine it's an area that's covered by, by programs for states that have, dispensers that go through an educational program. So that, like, as an example of something in addition, that's really common nationally to hear. And I know a lot of dispensers like go and take these classes and you're like, what are you doing? You can't do that in California. You can't practice that in California, but I can do it somewhere else. Yes, you can, but not here. And here's why. So, similar to what Sharice was just saying, I think I would have a hard time as a board member, as a dispensing audiologist board member, as just a board member, pushing for it. But I wonder if the community at large of dispensers in the state, have talked about it or would consider it, or if that's something of interest to the field at large. I'm not sure that I feel like I want to go with the statute and kind of force something.
I would also say that I've heard from the community at different times that there is some amount of agreement that there used to be a community college that had a course or 2 courses, that was helpful with the limited scope that you have, maybe not an associate's, but some number of coursework that the community college has provided. There's a variety of things to question mark in there.
Yeah.
Just knowing we have the statutory authority to start exploring something, if that's helpful. Okay. But that leads to the question of, thank you for bringing up the letter, but if we're going to look at workforce shortage issues, then we probably should look at this more broadly and not just let's water down the supervision requirements for what we're supposed to be getting a trainee ready to take and pass examinations in 6 months, and instead looking at, or both looking at different tracks. We can have many trains on different tracks at the same time. Looking at how do we implement some sort of educational requirements, or just like the OTs, I don't know. I would have to ask the Occupational Therapy Board, what did it cost to work with the community college to do this workforce study? And how did it work? What kind of involvement? Was there a cost? How can we do something like this so that we're gathering the information we need before we decide to use the statutory authority to do anything? If there's even an appetite to do so.
I think that's the biggest question.
Right. Is there an appetite to do so?
I think we'd have to identify first what areas you would want to expand the scope of practice. Because if you're trying to decide, is there a program? Well, then what are you going to fill that program with? So we then have to take that step of, okay, what does that mean?
Yeah, and I think a good first look would be to pull what the other states are doing that do require it and see what that content is like, et cetera. So I think there's a lot of places to start. We wouldn't be the first. So that's nice because there are other examples.
To look at what others are doing.
We wouldn't have to reinvent the wheel.
Correct. Now, whether or not that's something to pursue at this time, I don't know.
And again, it just says required course of instruction or otherwise satisfy. So again, the statutory authority is somewhat broad, and then the board can look into and then eventually promulgate regulations about it. Again, scope would have to be statutory. So again, and the board pursues things when they're in the consumer protection avenue. But again, we are always partners. Our associations are partners and stakeholders. And to the extent that our public protection mandate intersects with the advancement of the profession, that's always an opportunity. Sometimes the first step, of course, is look at a workforce study to see what are we actually talking about in reality in those workforces, and to get that input, because I think there is a little bit of a disconnection between the trainee and how we, as the board, envision it to be a training and experience mechanism to pass exams and become a hearing aid dispenser versus, hey, I don't have support personnel, and what I really need is support personnel, or I really need to be able to do this, but I can't.
Or there aren't enough hearing aid dispensers that are licensed out there for me to hire, so I'm going to home grow my own. And I think is what happens a lot. It's certainly what happens we use with our health technician at the VA, that no one has that experience already. So you have to take someone who has no idea what they're doing and teach them every single thing about it. And it's incredibly labor intense. But that's probably, I would imagine that's in most cases what's happening. Oh, I'm going to get them a trainee license and I'm going to home grow my own. But it's like, okay, well then, but now you have to put the work in. They can't just be on their own. So,
and I've had that question before from students in the outside world is, I have no relationships with anyone in the profession. How can I get training as a hearing aid dispenser?
Yeah. A lot of bachelor students.
There's no public way to go.
There's no pipeline.
Yeah.
There's no path.
I would also, and I hate to mention it because it means it's my job, but outreach as well, where the board provides, here's the pathways, and here's the things to look at.
Right.
We can't always make it big. It doesn't always mean people will go that way, but contact a hearing aid dispenser near you. You can look them up
those
here.
require you to then become an employee of whatever that is. You've got to work there, so it just may not be an option. No one's hiring, or they don't want you,
or they don't have room, right?
Well, for the expense.
Right. Exactly. They just don't want to. It's costly.
Yeah.
And I would just also point out, community colleges do seem to always be open to look at new ways to provide new pathways and new coursework. I would also say that just so all stakeholders are listening, the legislature loves to hear about additional ways to get people working, right? They want to find ways to enhance the workforce. And so if you're an association and that's what you're looking for, that's also something they'd love to partner with people. Again, as the board, we just want to ensure the experience, education, and training and skills all match up with whatever they're going to be allowed to do. And then that we, use like mechanisms to measure these things.
I have a question, their point about the waivers. Is there a cost for a waiver?
No.
What's the time frame to get approval for a waiver? If I want to take on a second apprentice today and I went on the website to apply for a waiver.
Probably a couple of weeks.
Couple weeks.
But you do have to apply to the board and you have to get approval. Now the hesitation.
And that's through the website?
I want to say yes, but I do not have.
We have an easy way for that to happen?
I believe so, but I will double check.
Okay.
That would be my head licensing analyst who takes care of all of that. And I don't have her in the room with me. So that would be helpful. The other point being, we would also have to consider you have other trainee on your license and or have they passed the exams yet? Where are they at? Those are kind of considerations to think about.
So if I have a trainee that hasn't passed the written exam yet, and I decide I want to take on a second trainee, there would be the potential to not approve the waiver because the other one hasn't passed the written test yet.
Because we haven't had any experience to show that they are on their way towards licensure. At which point, when they fail the written exam, they move to 100% supervision, and you're not going to supervise both, right?
Right.
So there are these differences. So an RPE, right? When an audiologist or speech pathologist gets an RPE, they have already taken their education and done 300 clinical clock hours, right? They have to pass their praxis exam, but they have a year in which to do that. They're practicing during that time based on their education and clinical experience. They will get stopped at licensure if they don't pass the praxis, but most of them have passed the praxis when they actually apply for their RPE. The vast majority are passing their national exam before they even start their RPE. So it's a little bit of a different conversation for all of them. And so the hard part is for hearing aid dispensers, we don't have that. We have they already taken some exams yet? Are they just out there and you could potentially have 3, but now you need one of them to go to 100%, and now you need to drop 2, and where are they going to go? So the problem is creating this system where if we approve more, but you have to revert them to a higher level of supervision because they haven't displayed basic knowledge competency or skills competency with the exams, then we have difficulty. But a lot of times I'm seeing written exams not happening until much later, right? So you got one person who's not taken or even applied for the written in 12 months. They're at the 12th month mark, and oh my goodness, I need to apply for the written exam because I need to renew. And we're like, you can't renew because you haven't taken and passed the written exam. You haven't even just tried to take the written exam. So that's where this disconnect, and then us here at the office having people complain, well, I don't have the training, I'm not ready. Well, that's a problem. That means you've been working for a year and you still don't feel like you've had the training and experience to come take the written, let alone the practical. And there's only 6 months left on the 18-month time frame.
Right.
So,
which is like for me, when I've had people that want to become dispensers, and in my case, it's almost always bachelor's students. They completed their bachelor's, they don't want to go on to grad school, and so they would come to my office and want to observe and in hopes of becoming a dispenser. And in those cases, a lot of times they wouldn't even go the trainee path. I mean, they would be there like observer. They would be side by side all day long watching me do the things, and we would have all the discussions, and they would just start trying to pass the exams on their own, because honestly, like to come and cold and from zero, and then within 6 months be expected to pass exam, that's a really tall order. It's a tall order for a student that got a bachelor's degree in speech and hearing sciences, because all of the practicalities of the on the job stuff that you don't learn, with a bachelor's. So it's a big ask to have someone, get them start from zero. Okay, go get your trainee license, and only then are we going to start working together, and then have that expectation that they're able to pass those. So.
I have heard of one employer that actually puts them through training before letting them apply for the training license, so that they are more likely to pass before the 6-month mark.
Yes.
That's their effort to front load the education portion before paying the training license, and if they're essentially trying not to waste time.
Or money.
Yeah. Mm-hmm. So they're employed and getting paid to do the training and like intensive training, and let's go.
Right.
Mm-hmm.
Right. So the private market is sometimes trying to take care of this need, but some of this we have the authority, we just have never touched it. Right. And do we want to?
Is there the will?
Yeah. And I think the letter brings up some interesting questions that even if it didn't intend to bring them up, right? It may not have been thinking of them in those ways, but that's where it led me. If we're talking workforce shortage, and you, just like the audiologists and speech pathologists, need to see more clients, and you need to focus on the fitting and selling of hearing aids, what sort of support personnel do you need at your office that we should be licensing in order to protect consumers, but also to make sure you can operate your office?
I'd be curious to know what other dispensers how they would answer that question.
Yeah.
Because to my mind, it's basically all that support stuff is being done by front office already anyway, and it's perfectly within their purview to be able to do that. So.
Well, and I would tell you that when it comes to speech, if you're going to be assisting the speech pathologist with a lot of things, you need a speech aid. But we don't have that on the hearing aid side.
But it's kind of like that in audiology too.
I know.
Right.
I know.
So
I'm just pointing out the
well, what they do is fairly minimal. It's not a lot, but it is that support function. It's a free me up to do testing and things, so I don't have to do the clean and checks or whatever if they want.
Right. So right now, because you're a dispenser and not an audiologist or a speech pathologist, you get to just let your front staff do that instead of having to go through the aid process.
Right.
I would just hint that the reason we had aids originally is to make sure that consumer protection, anybody handling patient and client records, potentially touching the patient and providing patient care of varieties, was to have them registered with the board.
Well, but see, that's the difference. It's because they're not touching the patient. So,
but they're still looking at patient records and handling them.
Well,
I'm just going to put it out there, saying it out loud. But it begs the question of, do you need enhanced support personnel because of workforce needs?
Yeah. So, I mean, I would say, looking at this ask, the having to ask for a waiver to supervise 3 trainee applicants, I don't believe having to ask for a waiver is onerous. And I think the reasons you gave as to why, the board wants to be able to make that decision makes sense, because it depends on where you are in the process with your other trainees and what's going to happen if one of them revert to immediate supervision 100% of the time. That makes sense to me.
Yeah, all right, me as well.
Okay. Reciprocity, I think we've covered that as much as we can. I don't think we have a lot more to discuss on that right now.
We just want to make sure you're aware of what's required. I think there's a lot of times things that people think California just doesn't want to discuss it. Well, no, it's because we have a policy and we haven't done the things to get to that policy to verify it.
And Todd, I don't know, on the direct supervision, immediate supervision on failing an exam, if you were taking a position there or you had a thought there, I'm not quite sure what.
I don't have an issue with, but I mean, see, we've kind of gotten away from the percentage, so it's a moot point in the new rule. So, I mean, I don't have an issue with it being 50-50 direct versus immediate if they do not pass the written test. But it's a moot point because we're not talking about percentages anymore anyway. So I don't see how that would actually work within the discussion of how we're looking at changing the rates on that. So I don't think that's a problem. But
else to add?
Nothing else to add.
Anyone else awake?
No, there's nothing here to add either.
Nothing here to add.
Thank you for hanging in, SLP crowd.
Yes.
There's a lot of hearing aid dispensing today.
A lot of learning going on over here.
Whether you want to or not.
They all want to.
Yes, we do. Yes, we do.
That's right.
Taking notes. All right. Okay, so it's hearing no further board discussion. May we open it up for public comment? Are you all ready?
Absolutely. There are no
Okay.
members of the public at the Sacramento location.
All right. And for those of you logged into WebEx, if you'd like to make a comment, please raise your hand. We are displaying instructions and we'll give you a moment.
All right, thank you. And there's no members of the public here at the Glendora location. And what about the City of Industry?
Hi, this is City of Industry. There is no one here for in the public.
Okay, thank you. We will go ahead and move to requesting the moderator to open for public comment on WebEx at this time.
Thank you so much. If any member of the public would like to comment, please raise your hand. I do see a raised hand from IHS Sierra Sharp. So IHS Sierra Sharp, if you see a prompt to unmute yourself, go ahead and click on that.
Hello, thank you so much. Can you hear me?
Yes, we can.
Thank you. So this is Sierra Sharp, Director of Professional Development at the International Hearing Society. Again, didn't get to quite finish my thought, ended a little abruptly before. Would just thank you so much again to the board for considering these really important topics and spending so much time talking about hearing aid dispensers and these issues within the profession. To reiterate, IHS is ready and willing to give a presentation to the board, participate fully in a linkage study regarding the national exams that we offer compared to the California hearing aid dispenser exams. And as part of that, IHS would definitely request the board consider matters related to reciprocity, such as those you've discussed today, to reduce red tape for qualified applicants from out of state. Other states who have adopted the IHS exams, such as Oregon and Washington, have seen reduced costs and administrative burden for the board, which allows the board to operate leaner and or focus on other issues, as well as ease of licensing for qualified individuals moving in from out of state. Thank you again for taking up these topics and for your time today.
All right, the next request for comment is from Thomas Tedeschi. And Thomas, if you see a prompt to unmute, go ahead and click on that.
Thank you. And can you hear me?
Yes.
Okay, thank you very much. Just 3 points, actually. The first is I'm the Chief Audiology Officer for Amplifone Americas. And so we operate numerous offices throughout the state of California and across the country. But first of all, we would definitely endorse all the changes that are in the August 23 actions that you've taken into consideration. Those are great. Just two other points. Number one is on reciprocity. One of the difficulties that we run into is if we're having somebody from within the state of California, we don't run into too many problems, but trying to bring, because of our needs from outside the state of California, who may be licensed in another state and practicing for 4 or 5, 6, 7 years. It's very difficult for them to come to California. It's a barrier for them because they do not want to retake all the exams and start out again as a licensed trainee. And so if we could adopt or look into the suggestion of looking at the ILE and being able to measure those two together, that would be excellent. The third point is, as you were talking this afternoon about support personnel, in a number of states, they have dispensing assistants or dispensing aides. And this is a nice flow upward for like an individual who's a front office person who would like to maybe look into the dispensing of hearing aids. It's a nice flow upwards where they could become a dispensing aide or a dispensing assistant. And then from there, they could then move up and become a trainee to become a licensed dispenser. So it's a nice flow upward. And we see this in a number of states, this taking place, and to help alleviate the workforce burden. But it gives an individual who's a front office person that time to have an experience now as an assistant or as an aide. So just some suggestions to look forward to in your next agenda maybe item is looking at that dispensing assistant or dispensing aide. Thank you very much for your time.
All right. And our next request for comment is from Joe Bartlett. Joe, you should see a prompt to unmute yourself.
Thank you very much. Joe Bartlett, I'm the legislative director and past president of Hearing Healthcare Providers of California. And I know there's been a few mentions of, what the board doesn't want to dabble in. They do point over towards the state associations and let us kind of handle some of the more business related or practice related things that are not dispensing or in the scope. And often it does turn out we point people looking to us, like, how do I get a trainee into it? We point people to, for years, and even myself, the distance learning program from IHS. It is actually an educational program where I do agree if there's like a program created at the community colleges, there's not going to be enough students per semester for them to have that as a continual thing. However, if those that are looking to get educated, looking to get trained, have a training program already available to them, it would be it wouldn't behoove us as a state to not consider what's in that scope of practice and what's in that curriculum. I feel like in the long run, there are dispensers who are working under ear, nose, and throat doctors, because when you're not fitting and selling a hearing aid, you have the skill of doing hearing testing and the ability to do some of the things that are done as a national level in California, people can do, hearing aid dispensers can do. So I think that in the long run, we're probably going to see the scope of practice change. And this is, I think, the step one in getting to the point where we're getting the best person in front of that patient, so that they get the best care and we get the best training, we get everything. As an owner of multiple practices, if I needed a person tomorrow because of sickness or some sort of thing, I would have nobody to put into that chair, because I could not hire a trainee, turn around. There's nobody available for me to just hire and come in and do it. I'd have to train within. It would take me 18 months. So if I had the ability to say, is there somebody who's been trained to the standard that I know is great that I could hire and bring in, that would be a huge benefit for me. And I know other of private practice owners throughout California would agree. If there were trained hearing aid dispensers that were able to come into California and work, it would be a huge asset. So again, thank you for listening, and I appreciate you guys having this great conversation today.
All right, this is the moderator. I see no further requests for public comment. Madam Chair, I return the floor back to you.
All right, thank you. Okay. I'd like to move on to agenda item 19, the regulatory report, update, review, and possible action on board regulation packages. I'd like to now ask Ms. Lorenzo to present information on this agenda item.
Thank you, Ms. Dominguez. My report is pretty short. There's no board action required. The first two items, processing time and audiology supervised clinical experience, are with the Office of Administrative Law. And we're expecting their decision September 23, 2025. If approved, it would have an effective date of January 1st, 2026. Audiology, the supervised clinical experience didn't have any public comment, so we were able to move forward with the rulemaking process without any additional board action during the summer. The rest of the items, there's still no changes to their status. We are working on the disciplinary guidelines, so a lot of them have been on hold for that, especially the HAD trainee supervision rulemaking, as well as the HAD and dispensing audiology examination requirements. Approved institution has been held for further analysis on the text. And then the last item on fingerprinting requirements, we do have a fiscal impact that is holding the packet. Other than that, that completes my report.
Thank you. Thank you for presenting this information. I'd like to now open it up for board discussion.
Just because CAA presentation is coming up in 4 weeks, and I know that the application requirements, practical exam issue for audiologists will, as always, be the number one thing everyone wants to hear about. And I know it's been delayed for a number of years. Do we have any idea? Is there anything I can say about an expectation of time frame on this that would be reasonable?
Unfortunately, it's really hard for me to determine when rulemakings will get moved, because I do have other workload as well. I also do a lot of the legislative workloads. That's included in, legislation is included in my workload. Meeting materials is included in my workload. We are required to create a rulemaking calendar. So at the end of the year, and it's due to the Office of Administrative Law in January. So that's probably the earliest I can probably get an idea of when that rulemaking would move forward, could move forward.
Is there any other board discussion? Okay, thank you. Hearing none, I'd like to open for public comment. We'll start with the on-site locations. There are no members of the public here with us at the Glendora location.
I'm at the City of Industry location. There are no members of the public here.
There are no members of the public at the Sacramento location.
All right, thank you. I'd like to ask the moderator to open public comment on WebEx at this time.
Thank you, Madam Chair. If any member of the public would like to comment on agenda item 19, please raise your hand. We are displaying instructions and we'll give you a moment. All right, this is a moderator. I see no request for public comment at this time. Madam Chair, I return the floor back to you.
All right, thank you. Moving on to agenda item 20. Regarding future agenda items, I'd like to ask board members and staff if there are any future agenda items that they would like to propose for a future meeting. Okay.
Do we want to put the ILE on as a future agenda item, or we basically already talked about it and done that?
I think we were planning
we
to
need
get
to
that to have
Yes,
IHP
please.
present.
Yeah, we would like
Yes,
that.
please.
Please.
Okay, Francis.
I would like to request that a discussion for the requirements for SLPA to consider foreign bachelor's graduate, foreign trained bachelor's degree to fulfill the educational requirement.
Can I clarify, do you mean the SLPA, not the aid? Because there's no education requirement for the aid.
SLPAs, because especially as assistants, I'm sorry.
Yeah, SLPAs, SLPAs.
Yes, the SLPAs.
Currently, that's a statutory requirement, so I will just tell you that, at least.
Okay, any other future agenda items for proposal? Okay, so we have the two for the IHS presentation and for the foreign trained SLPAs. Okay, thank you. I'd like to open for public comment. We'll start with on-site locations. There are no members of the public here with us at the Glendora location.
There are no members of the public here with us at the City of Industry location.
And there are no members of the public at the Sacramento location.
All right, thank you. I'd now like to ask the moderator to open public comment on WebEx.
Thank you, Madam Chair. If any member of the public would like to comment on future agenda items, please raise your hand. We are displaying instructions and we'll give you a moment. All right, this is the moderator. I see no requests for comment. Madam Chair, I return the floor back to you.
All right, thank you. With regard to agenda item 21, closed session, the board meeting in closed session pursuant to Government Code Section 11126C3 to discuss disciplinary matters, including proposed decisions, stipulated decisions, defaults, petitions for reductions in penalty, petitions for reconsideration, and remands. We do not have any of those matters to discuss. Therefore, the meeting will be adjourned at this time at 2:26 p.m. Thank you.
Thank you, everyone.
Great job.
Have a
Thank
good
you.
weekend.
Have a nice weekend,
Thank
everyone.
you. Thank you.
Bye-bye.